We're on live. We're live.
We're on live stream right now, just to let you know.
Can you hear us?
Morning, everyone.
Good morning, Cassandra. Catherine, can you hear us?
I can.
Good, okay. We're on live stream now, so.
I'm gonna go ahead and mute again.
Springfield, can you hear us in Chicago?
Yeah,
We can, and we are already on live stream, just to let you know.
Yeah, that's, yeah.
at long lines in Chicago to check in. We have a line here. So we're gonna wait a little bit. We won't be starting right on time.
Yeah, I might grab a couple.
For Chicago, you could go ahead and mute again.
Two others that were
We need to have Jennifer for quorum. Marnie, Bernadette, we ready? Oh, unmute. You're muted.
Who has Jennifer's? Let's see.
Have that.
I think it's Cassandra.
Jennifer's problem.
I don't have, I didn't have.
But Jennifer is in the garage trying to get upstairs.
Okay.
Marnie, are you ready? Can't hear you.
You're muted.
Springfield, can you hear me?
Now I can.
Excellent. We still have a huge line of people, so if we can wait about another 5 minutes, I would really appreciate it.
That'll work just fine. You just give us the high sign when you're ready.
Thank you, ma'am. We're also still waiting for Jennifer.
Yes, she's on her
Just
way.
wanted to let people know we are calling a lot of cases today. So if your case number is higher than, I'd say, 545, I would suggest going into conference room D, which is the overflow room for a while. You'll be able to watch the meeting, and then when some of the people depart this room, you'd be able to come back over here for your case. So if you have one of those really high number cases, it might be easier for you to spend a bit of time in conference room D. Thank you.
Okay, so you're on regular board agenda. So you can come up here. Where are they? But me, now, I'm gonna sign this one. They have regular board agenda, now D. Sorry.
All right.
Sorry.
Springfield, can you hear me?
I sure can.
Excellent. Well, we have a whole lot of people here. There are still a couple people trickling in, but I think we should get started if you are ready.
We are ready.
And to you, Madam Chair.
Thank you. You're welcome.
All right.
Yeah. The early.
Oh, it's 5:22.
I'm having some, are there people talking in the microphone or what's? Can you hear me, guys?
We can.
Yeah, we hear you.
Okay, all right. I will call the meeting to order. It is November 18th, Tuesday. It is a little past 9. And I will call the meeting of the State Board of Elections to order. If you'll stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have if there's a mic on somewhere where we can hear voices.
But just so everyone knows, the little green lights in the ceiling, they're ceiling lights. So if you're talking in a crowd, it's gonna go up and they're gonna hear it on everywhere else. So please
Laura?
press it now.
Are you able to hear us?
We can hear you, but we can also hear a lot of other stuff, but we're
Okay.
fine now. All right,
Okay, sounds good. Well, if everyone in the audience can remain quiet to make sure that we, the board members in Springfield can hear us, that would be wonderful. I'll call on you when it's your turn to introduce yourself. So I'm sorry about that, Chair. Please go ahead.
all right. Thank you, Marnie. Amy, roll call, please.
Ms. Bellicroft,
Present.
Ms. Craig,
Present.
Ms. Genovese, Ms. McCrory,
Here.
Mr. Brett,
Here.
Ms. Watson,
Present.
Vice Chair Turbin,
Here.
Chair Donahue.
Present. All right,
Very good. All right.
we will start with, consideration for. Oh, sorry, I skipped one. I need a motion to approve the minutes of October 21st.
So moved.
Second.
Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, next up is consideration of lack of apparent conformity of candidate petitions. Marnie?
Thank you, Chair. Bear with me for 1 second and I will pull that up. Okay, so we have 2 cases on the agenda for consideration of lack of apparent conformity of candidate petitions. One of them, item 2B, Thomas Rudd for representative in Congress, 10th Congressional District, has already withdrawn from the race. So there's no need to vote on that one. Instead, we will go to agenda item 2A. It's John Manerick, representative in Congress, 10th Congressional District. For this office, Mr. Manerick was required to file 995 petition signatures to gain ballot access. He filed only 3 signatures, one of which was his own. Under section 10-8 of the election code, nomination papers being filed as required by this code and being in apparent conformity with the provisions of this act shall be deemed to be valid unless objection thereto is duly made in writing. The state board's apparent conformity standard requires at least 10% of the minimum signature requirement on the face of the petition to be deemed in apparent conformity with the election code. In contrast, it's my understanding the Chicago board requires 100% of the minimum signatures appearing on the face of the petition under its apparent conformity standard. So our 10% standard is quite low. Here, there is no objection pending to the candidate's petition. So unless the board rejects the nomination papers for lack of apparent conformity, then Mr. Manerick's name will appear on the 2026 general primary ballot for a U.S. Congress nomination, despite having only 3 signatures. Is there a motion to reject the nomination papers of John Manerick, candidate for representative in Congress for the 10th Congressional District, due to a lack of apparent conformity under Section 10-8 of the Election Code?
Is there discussion, questions? Do I have a motion?
There is a question.
Questions cannot come from the audience at this point. Questions can only come from the board. Thank you.
A motion, please? Motion?
Make a motion to accept the recommendation of the general counsel and reject the petition.
Second.
It has been moved and seconded. Amy, roll call, please.
Ms. Bellarcroft,
Yes.
Ms. Craig,
No.
Ms. Genovese?
Yeah.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
present,
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right. Thank you, Amy. Do I have a motion? We will now recess into the state board of our state electoral board. Do I have a motion?
So moved.
Second. Amy, roll call, please.
Ms. Bellarcroft,
Yes.
Craig,
Yeah.
Ms. Genovese,
Yeah.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
yes,
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right. Now we will convene as the State Board of Elections Electoral Board. Roll call, Amy.
Ms.
You do a
Bellarcroft,
lot of that.
Present.
Ms. Craig,
Present.
Ms. Genovese,
Here.
Ms. McCory,
Present.
Mr. Brett,
Here.
Ms. Watson,
present,
Vice Chair Turbin.
Yes.
Chair Donahue.
Present. All right, now that that's all taken care of. Marnie, introduction to our electoral board process, please.
Absolutely. Thank you, Madam Chair. Good morning, everyone. My name is Marnie Malowitz. I am the general counsel for both the State Board of Elections and the State Officers Electoral Board. We are convened right now as the State Officers Electoral Board under the Election Code for the purpose of hearing and passing upon objection petitions filed to nomination papers for established party candidates for the March 17th, 2026 general primary election. The board's goal is to provide all the parties with a fair process before the board rules on objection petitions. A hearing officer will be assigned to all cases to ensure each case is given the attention it deserves. Shortly, I will call the cases for objection petitions under the jurisdiction of the State Officers Electoral Board. I will call the cases by case number as well as party names, first the objector and then the candidate. I will acknowledge any appearances that have already been filed to date, and if none has been filed, I will ask if any parties are present on that matter. When your case is called, if I indicate I do not have your appearance form yet, please speak loudly in introducing yourselves to the court reporter, and everyone in Springfield can hear you. There are green lights on the ceiling in Chicago. Wherever you see a green light is a microphone, so direct your voice in that direction. Please be aware that any appearance filed in the last couple of hours may not have made its way to me yet. So if I ask if you're present, you can indicate verbally that you just filed your appearance. I'm unfortunately not able to get everybody's appearances in real time, so please be patient. Attorneys, please be sure to spell your last name for the court reporter, if your names do not appear on the electoral board agenda. Parties, however, do not need to spell their names when they speak because their names are already spelled and listed on the agenda. Immediately following the call of your case, or if you have multiple cases, your final case to be called, if you are in Chicago, please proceed to conference room D, which is on this floor, to wait for your case to be called by the hearing officer. If you're in Springfield, please head just outside the board meeting room. SBE staff will help you locate the hearing officer assigned to your case to hold your initial case management conference. We have an unprecedented number of cases this year, so I appreciate everyone's patience as there will be waiting time involved before you meet with your hearing officer today. Here are a couple of other important pieces of information. First, no evidence or arguments on your electoral board case will be heard today by the board or by your hearing officer. Today's initial meeting with your hearing officer is a procedural conference only to let you know how this process will work. Immediately after the cases are called, the board will be adopting rules of procedure. These rules of procedure will be available both on our website and in our petition portal, which I will talk about in a few minutes. Please read and review the rules of procedure very carefully and as soon as possible. These are expedited proceedings that move very quickly, and the deadlines for next steps in this process begin this Thursday with the filing of motions and subpoena requests. There will also be records examinations beginning this week on Thursday. All of the dates for subpoena requests and motions are in the rules of procedure. Dates for records examinations will be posted on our online portal. Going forward, any questions you have about the rules or about management of your cases should be made directly to your hearing officer. I'm going to do a brief introduction to the petition and objection portal. So before I call the cases, I'd like to introduce the board's new petition and objection portal for the filing and service of documents in each case. This new feature offers one central location for parties to access all documents in their case, as well as SBE forms, the rules of procedure, and record examination schedules. Parties, your hearing officers will provide you with hard copies of the portal instructions, as well as the rule of procedure I mentioned a few moments ago. A training video is also available to help you familiarize yourself with the portal, and that will be linked in the instructions that are provided by your hearing officer. Parties will be required to make their filings through the portal unless they encounter technical difficulty. If a filing is uploaded to the portal past its due date and time, the party will have to show good cause to the hearing officer why the filing was late. This is all explained in Rule of Procedure 6, which will be handed out by your hearing officer, and I encourage all the parties to read it very, very carefully. I'd like to extend a tremendous thank you to Chris Paper from our IT department, who devoted significant time and effort to building this portal from the ground up. Thank you to Jordan Worth for making the visual appearance of the portal so user-friendly. And thank you to our Deputy General Counsel, Jordan Andrew, who led this innovation for the Office of the General Counsel and worked with IT staff in the development and testing of the portal. This is a fantastic new feature. It will benefit the parties by giving them quick access to all the filings in their cases, as well as forms and notices of records examinations. The portal will also improve efficiency for board staff and hearing officers in administering the electoral board process. If you as board members would like access to the portal to review case documents, there is an instruction sheet in your packet. If you look on page 1 of your packet, you can follow the instruction there in order to gain access to the portal. And Madam Chair, should I proceed to calling the cases?
Just a second, please, Marnie. Member Craig.
Marnie, I just have one question. How long is this portal going to stay up? And this is my concern. I'll tell you my concern. I know the General Assembly, and I know Brian can give me the bill number, just passed a bill about addresses and public safety. And I know the governor has not yet signed that bill. But when that happens, I'm concerned about all the addresses that are on here. I know there's other ways they can get these addresses, but I just wanted to know there was no deadline when this portal was going to be taken down.
Sure. So if this act is passed, obviously, or is signed by the governor, obviously we'll read it and be sure to comply. But there are special rules for candidate petitions that make them FOIable and available to the public. Now, in terms of taking down the portal, we can absolutely look into whether the portal can be taken down immediately once the board has ruled on the cases. but I haven't discussed that particular issue yet. But I will, thank you for pointing out that legislation, and I will make sure that our legislative analyst follows that legislation to ensure we're following it.
Thank you.
Thank you. I would like to take just a second before we do the call of cases. Marnie did indicate that it is an enormous number and an unusually high number. The last couple of weeks have been rather stressful with petitions and filing and checking and all the things that have gone on. And I just want to say thank you to all the staff in all the things that you've done to get us prepared for this morning and for this meeting. So just thank you for all that you do, believe me. All right, Marnie, please proceed.
Thank you, Madam Chair. So before I begin calling the cases, I just wanted to remind you, after your case has been called in Springfield, please head to the area where you entered the building, just outside the board meeting room. And in Chicago, please proceed to conference room D, which is on this floor. Staff on this level will assist you in finding the right location. I apologize in advance if I mispronounce anyone's name. I do my best, but feel free to correct my pronunciation when I call your case. And again, if you recall, I may not have your appearance yet, if it's coming in the last bit. And here we go. 25 SOEB GP 100 Statham versus Bryant. I have an appearance on behalf of objector by attorney Robert Winden. Is Mr. Winden here?
I am. I crossed that off. I did not send in my appearance on
Oh,
that matter.
okay, I apologize
It's
for
okay.
that.
I just don't want to.
Okay, is anyone here on behalf of objector Statham? STATHAM.
Yes, attorney Tyler Smith, spelled SMITH, on behalf of the objector, and my appearance is following this matter this morning.
Excellent, thank you, sir. And is candidate Bryant present?
Attorney Jeffrey A. Meyer, MEYER, on behalf of the candidate.
Excellent, thank you, Mr. Meyer. You can proceed to conference room D unless you have other cases to call. 25 SOEB GP 101 Bowlby versus Tabrouge. Is anyone here on behalf of objector Bowlby?
Yes, Robert Winden, WINDON.
Thank you, sir. And is anyone here on behalf of candidate Tabrouge?
Yes, we here
Springfield.
in Springfield, Marnie.
Excellent.
Speak to that.
Is it Mr. Tabrouge or is it his attorney?
T-Berg.
Yes.
Seberg. Oh, wow, I botched that one. I'm
All right.
sorry.
Spell, identify yourself.
Yeah.
and name.
Judy Bowlby, last name BOWLBY.
But it's the candidate present.
Yes,
Yes,
Mr.
yes.
Tabrugi's here.
I don't know if you can see.
Okay,
Yeah, there you can. Spell your name and identify.
okay.
First name is, I'm sorry.
Go ahead.
First name is Ryan, RYAN. Last name is pronounced Teberg, TEBRUGGE.
And sir, you're the attorney for the candidate?
No, I'm the candidate.
He's the
itself.
candidate.
Oh, okay. For 101,
Yes, ma'am.
Tabrouge.
Teberg, like iceberg with T, Teberg.
Okay, excellent. Sorry about that. Okay, excellent. 25 SOEB GP 102 Collier versus McKinney. I have an appearance on file from Mike Casper and Kevin Morphew on behalf of the objectors. I believe I saw them.
Yes, President Kevin
This
Moore.
morning. Thank you. And is anyone here on behalf of candidate McKinney?
Yes, here in Springfield, Marnie. Come up to the microphone.
Excellent. Is it candidate McKinney or is it an attorney?
Candidate McKinney, ma'am.
Excellent, thank you, sir. Next case, 25 SOEB GP 103, Betts versus Johnson. I have another appearance on file for objector by the team of Casper you. Is anyone present on behalf of candidate Johnson?
None here.
Okay, thank you. 25 SOEB GP 104, Malo versus Lauren. Is objector Malo here? Malo. And is anyone here on behalf of candidate Lauren?
Yes.
Yes?
Right in Springfield, please.
Okay, excellent. Oh, okay, I see, Attorney Atsaves, ASTAVES has filed an appearance as well.
That's correct.
Excellent. If you can bear with me 1 second, just to see if, objector Malo has been served. Not yet, so we will move on to the next case. 25.
Wait, whoop, Marnie, what does that mean if
So if an objector has been served and they don't show up today, their case could be dismissed for want of prosecution. But if they haven't been served, we're not going to dismiss their case because they don't have proper notice of this meeting. So some of the certified mail deliveries have been pretty slow in getting delivered to objectors and candidates. So we're just going to hold on and give this objector some time to appear to make sure that they're properly served.
So what should the attorney present here do? Wait, just hang in there, or?
They should also proceed to wait for their hearing officer. And if objector Malo appears, wonderful. But if not, the hearing officer conference will proceed without Mr. Malo.
It's not.
So.
My brother Chris.
All right, thank you, Marnie. Thank you.
Thank you. If people could please keep it down, I would appreciate it. The next case, 25 SOEB GP 105, Hallbrook versus Haig.
Yes, we're here. We have Mr. Haug and Mr. Hallbrook.
Excellent. If they can both ensure that they filed appearance forms, that would be wonderful.
I have Brad Halbrook. I have an appearance form with me here today.
Okay, you can.
I did that when I came into the
All
room
right.
this morning.
They both have appearances. Who does he
Perfect.
give it to? Tom? Down there. Okay.
Someone
Go
in
towards
front
that door.
can
There
take
we
it.
go.
Thank you. All right. Next case, 25 SOEB GP 106, Durbin versus Moore. Is there anyone here on behalf of objector Durbin?
Right here, John Fogarty, Fogarty.
And have you filed your appearance already, Mr.
Not yet.
Fogarty? Oh, okay.
I know.
You'll do it.
Yep.
And is there anyone here on behalf of candidate Moore? Okay, thank you. No one. 25 SOEB GP 107, Levitt versus McComey. I see there is a signature here, but I can't read it. Is that the objector?
Who's that?
Yes, sir.
Look,
Levitt? Levitt.
Yep, you did
Okay,
good.
excellent.
Thank
Thank you. I got it right the first time, not the second time. And on behalf of the candidate, we have Mr. Fogarty for Senator McCombie.
Marnie, just a second. We don't have this one on our list. Okay.
Oh, is this a withdrawal?
Oh, it's on the last, it's on the next page, on page 3 at the
Okay,
top.
you found it?
One of those
107.
certified
Okay.
All right. Got it. All right. Continue.
Excellent.
Sorry.
No problem. Next case, 25 SOEB GP 108, Levitt versus Chesney. We have Mr. Levitt, present in Chicago. And on behalf of the candidate Chesney, we have John Fogarty, Fogarty. Next case, 25 SOEB GP 500, Chapman versus Krishnamurthy.
Chapman.
Thank you, Mr. Chapman. And on behalf of candidate Krishnamurthy, we have attorney Michael Dorff.
D-O-R-F.
Thank you, sir. 25 SOEB GP 501, Gordon versus Holt. We have an appearance for objector Gordon by Kevin Shepro. Is Mr. Shepro present? Okay, and we have an appearance here by candidate Holt, HOLT. Just a reminder, if your case has already been called and you don't have any more cases, please head to conference room D to wait to meet with your hearing officer. We need to free up some space in here for people who have the higher numbers, and our staff need to be able to find you in order to connect you with your hearing officer.
Candidate Holt's present for that case.
Candidate Holt, yes, exactly. Thank you.
Is there anybody here for the objector?
Yes, Kevin, well, not present, but Kevin Shepro has provided a appearance, and your hearing officer will have more information about that if you can proceed to conference room D.
Okay.
25 SOEB GP 502, Govindasamy and Talati versus Vedekad. I have an appearance on behalf of objectors by attorney John Lydon. Lydon, thank you, sir. Lydon. I should know this one. I know I've seen your name before. And on behalf of candidate Vedekad, we have an appearance by Robert L. Winden. Is that correct? Thank you, sir. 25 SOEB GP 503, Talati and Munchie versus Bean. We have an appearance again by attorney Lydon on behalf of the objectors, and on behalf of the candidate Bean, we have a appearance by Michael Casper.
Morning, everyone. Michael Casper, KASP.
KASPER. Thank you. Next case, 25 SOEB GP 505, Hall versus Templeton. Is anyone here on behalf of objector Hall?
Okay. You're Templeton? Okay. We have Miss Templeton here.
Okay, excellent. Wonderful, thank you. Next case, 25 SOEB GP 506, Henley versus Ramos. Is anyone here on behalf of objector Penley? Okay, and on behalf of candidate Ramos, we have an appearance by attorney Max Solomon. Is Mr. Solomon here?
He's not, I am.
Okay, and your name, ma'am?
Ashley Ramos.
Ashley
Ramos?
Ramos. Okay, thank you, ma'am. Next case, 25 SOEB GP 507, Abbott versus Claiborne. I have an appearance on behalf of the objector by attorney Jeffrey Meyer.
Yes.
And I have an appearance on behalf of candidate Claiborne. It looks like candidate Claiborne is here. Is that correct? Thank you, ma'am. Again, if anyone whose case has already been called, please proceed to conference room D on this floor.
Ms. Malwitz, I'm also appearing on behalf of objector on that case, Christine Svensson. V is in Victor.
Yes, thank you. No, I know you sent in your appearance, and our sign-in sheet just hadn't been updated yet. Next case, 25 SOEB GP 508, Abbott versus Solomon and Young. We have appearances on behalf of the objector by Jeffrey Meyer and attorney Svensson, SVENSON. Is anyone here on behalf of candidates Solomon and Young? No candidate Solomon, no candidate Young. Oh, okay, I'm being told that I skipped 504, so my apologies. I'll go back to that one. Govindasamy and Munchie versus Danang. I'm sure I'm botching those pronunciations and I apologize. I have an appearance by attorney John Lydon on behalf of the objector and an appearance by Michael Dorff on behalf of the candidates or the candidate. .509 Abbott versus Goodman. I have an appearance on behalf of the objector by Jeffrey Meyer. And I have, it looks like, is anyone here on behalf of, oh, we already, Solomon and Young. Is there anyone here on behalf of Solomon and Young? No, we already did that one, right? So 509, I apologize, let's back up. 509 is Abbott versus Goodman. This type is very small. It's challenging my eyes here. 509 Abbott versus Goodman. Appearance on behalf of the objector by Jeffrey Meyer.
In addition, Christine Svensson.
And Christine Svensson. I'm sorry, Ms. Svensson, your name isn't written in here. So I apologize. Hopefully I don't do it to you again, but I might. And it looks like Attorney Abbasi is here on behalf of candidate Goodman. Mr. Abbasi, if you could spell your name.
ABB ASI for Mr. Goodman. And I need to step out to do a Zoom court, but my brother, who recently became an attorney 2 weeks ago, he'll be stepping up for my other cases I filed.
Okay, thank you, sir.
Congratulations.
Next case, 25 SOEB GP 510 Smith versus Ufadiki. I have an appearance on behalf of the objector by Jeffrey Meyer. And on behalf of the candidate, it says something here, but I cannot read it.
Good morning, my name is Tasi DK. I'm
Oh,
a candidate
DK.
for state representative.
Thank you,
And
ma'am.
I have appearances submitted by my attorney that I can give to you.
Excellent. If you can give them to Adita right there at the front, that would be very helpful. Thank you very much.
Thank you.
Next case, 25 SOEB GP 511 Coghill versus Menarchik. Is anyone here on behalf of objector Coghill? Okay. Oh, this was the apparent conformity case that was already discussed, so we can scratch that one. Okay, 25 SOEB GP 514 Proctor versus Williams. It looks like on behalf of objector Proctor, we have an appearance. Is it Attorney Bolton? Thank you, sir. And is anybody here on behalf of candidate Williams? No one on behalf of candidate Williams for 514? Okay. Next case, 25 SOEB GP 515 Kearney versus Cowley. I have an appearance on file by the Odelson Law Firm for the objector.
Ross Seckler, SECLER on behalf of the objector.
Thank you, Mr. Seckler. Is anyone here on behalf of candidate Cowley?
Scott E. Erdman, ERDMAN.
Excellent. Thank you, Mr. Erdman. That was ERDMAN. Next case, 25 SOEB GP 516 Lye versus Parker. I have a appearance on file by Ross Seckler of the Odelson Law Firm on behalf of the objector. And on behalf of the candidate, I have an appearance by John Fogarty. FOGARTY.
I can say it. Thank you.
All right, next case, 25 SOEB GP 517 Zimney versus Delgado. I have an appearance on behalf of objector by attorney Michael Dorff. And on behalf of candidate Delgado, is candidate Delgado or their counsel present? Candidate Delgado? No one, thank you. 25 SOEB GP 518. Parent versus Solis. An appearance for objector by Michael Dorf. And how do I pronounce your client's name, sir? Harant. Thank you. You'll have to remind me of that at least once more, I promise. And on behalf of candidate Solis.
Present.
Thank you, sir. And you are candidate Solis.
Montez Solis.
Thank you. 25 SOEB GP 521. Dones and Sinkul versus Pasica. I have an appearance by Ed Mullen on behalf of the objectors. Is Mr. Mullen here?
Skip 21.
That's what I'm calling right now is 21.
meant 19.
19. Take a break, check in with me, sir, because I believe on 19, there was a withdrawal. The objection was withdrawn. So if you consult with our board staff, they can give you more
I can leave?
information. You can leave.
Said the objection was withdrawn
Withdrawn.
on 19.
Yes.
That's Brown, Tony Brown.
Yes.
Thank you.
Thank you.
Line, somebody show me out here.
All right. So, yeah, and same thing for 520. There was also a
22,
withdrawal.
I got a 22 too. I gotta wait for that.
Yes.
Oh,
Please wait here
Thank
until
you.
all of your cases have been called. Once your cases have been called, then you proceed to conference room D to wait to meet with your hearing officers unless you have withdrawals, in which case you can leave. All right, so back to case 521, Jones and Sinkle versus Pasica, appearance on behalf of objector by Ed Mullen. Is candidate Pasica present? No one in Springfield?
No.
Next case, 25 SOEB GP 522 Miller versus Brown. I have an appearance on behalf of objector by attorney Robert Winden.
Yes, Robert Winden, WINDON.
Thank you, sir. Is anyone here on behalf of candidate Brown?
I'm the candidate right here.
You're Mr. Brown.
Tony Brown, Tony C. Brown.
Thank you, sir. If that is your final case, then you can head into conference.
I can go now?
As long as you don't have any more cases.
So,
Great, head into conference room Z and you will end up meeting with your hearing officer. Next case, 523 Miller versus Moore. I have an appearance by Robert Winden, WINDON.
Correct.
On behalf of the objector. Is anyone here on behalf of candidate Moore? For 523, candidate Moore.
None here.
Can we close that door? I'm having a little trouble hearing. Thank you. Next case, 524, Fiedler and Smith versus Vajic. I have an appearance for Mr. Fiedler. Is there an appearance by Mr. Smith as well, or Ms. Smith?
Charles R. Smith here.
Thank you, sir. And is there anyone here on behalf of the candidate Vajic?
Yes, there is.
Thank you. And please introduce yourself.
Max Rice, my name.
And you're an attorney?
I'm not an attorney.
Okay.
She was sick.
I'm sorry.
She's sick. Excuse me.
Okay. Are you the candidate?
I'm not the candidate.
Okay, you cannot appear on behalf of the candidate unless, oh, you are the candidate, sir. Oh, that's Mr. Moore from the last case.
Dr. Moore.
Okay,
Yeah.
so if that is your last case, Mr. Moore, then you can proceed to conference room D so
D?
they can set you up with your hearing officer.
Thank you.
Great. So back to 524, Fiedler Smith versus Vajic. Only a candidate or an attorney can appear on behalf of that individual. So you will not be able to participate in this, in the status hearing. Next case, 25 SOEB GP 525 Lanigan versus Scala. I have an appearance by Heather Vaught.
Also Adam Bott.
And also Adam. Thank you, sir. I saw those came in last night, but they did not all make it onto my sheet. So I apologize for that.
I'm thinking left, right?
Did you appear on all of Heather's cases?
Yes.
Okay, thank you.
Isn't that fair?
And then on behalf of candidate Scala, I have an appearance by Mr. Fogarty.
OGARTY.
Thank you, sir. 526,
Oh.
Kidover versus LaHood. I have an appearance by Heather and Adam Vaught. And on behalf of candidate LaHood, John Fogarty.
I think I might be.
DARTY, that is correct.
Thank you. 25 SOEB G Little 526.
General Counsel,
Yes,
I don't believe,
the Vaught appearance is incorrect.
Yeah.
Thank you for telling us. We had a couple of those and I apologize for that. On LaHood, right?
that's correct.
Okay, I'm very sorry about that. I don't know how that made that in there, but I appreciate you pointing it out. So is anyone here on behalf of objector Kitover?
I'm Kid over here.
Oh, Kitover?
Kid over, KIT
Kitover.
over.
Thank you, sir. Next case, 25 SOEB GP 527, Kitover versus Noli. The objector is present, and I have an appearance on behalf of candidate Noli by attorney Ed Mullen. Is Mr. Mullen present yet? No. 25 SOEB GP 528, Johnson versus Henderson.
Anderson here.
I have an appearance on file by Heather and Adam Vaught for the objector. And on behalf of the candidate, Don Fogarty. 25 SOEB GP 529, Busk versus Mago. Thank you. Sir, I have you, and on behalf of objector, Heather and the Adam. 25 SOEB GP 530, Hannah versus Bro. So I have an appearance by Heather and Adam Vaught for the objector, and Mr. Bro is present. Thank you. SOEB GP 531, Newsome versus Severino and Isquith. I have an appearance by attorney Jeffrey Meyer for the objector, and Ms. Svensson as well.
Thank you.
And on behalf of the candidates, I have an appearance by Mr. Abbasi, ABBASI. And you're his brother.
Right, Christopher Abbasi.
Okay, thank you, sir. So you're also Mr. Abbasi.
Yes.
Excellent. At the 25 SOEB GP 532, Jacobo versus Dono. I have an appearance on behalf of the objector by attorney Kevin Morphew. Is that correct, Mr. Morphew? Where did he go?
He's down with conferences.
Oh, okay, all right, sounds good. As long as he's here. And is anyone here on behalf of candidate Donos?
I am the candidate.
Here in Springfield, Marnie.
Excellent, thank you, sir, and you can proceed outside the room to meet with your hearing officer. 25 SOEB GP 534, Williams versus Carrar. It looks like Mr. Williams has appeared on behalf of himself.
Yes.
Thank you, sir. And on behalf of the candidate, I have an appearance by attorney Ross Seckler.
CCLER.
Thank you. 25 SOEB GP 535.
Sorry, I had on 533, I had a appearance for the candidate.
I can't hear you.
Olson and Doctor versus Hannigan, 533, I had an appearance for Agent Paul.
So they just submitted their withdrawals within the last couple of hours. We can get all of that to you if you shoot an email to generalcounsel@elections.il.gov.
Yeah, no, as long as you do that, all the ones defending, that'd be great.
Okay, sounds good. Back to 535, Rice versus Abu Ghazala.
Abu Ghazala.
I was close, I didn't quite get there. So we have an appearance for the candidate by attorney Scott Erdman, ERDMAN. Is objector Rice present?
Yes, I'm here.
Thank you,
Thank you so
sir.
much.
Next objection, 25 SOEB GP 536, Rice versus Mendrick. Objector Rice
Same
is
person.
present. And is anyone here on behalf of candidate Mendrick?
Yes, Kent Mercado, M as in Mary, ERCADO. I did not put the case number on it.
Okay,
So that's probably you were a doctor. I didn't know you were a lawyer. I'm both. Oh.
doctor and a lawyer.
Yeah, there you go, double threat.
Whoa, whoa.
Okay, excellent, thank you. I'm sure the number will end up on your appearance form at some point.
Okay, and the candidate is here as well.
And the candidate is here as well, thank you.
So do we proceed to?
You can proceed to conference room D.
Thank you.
Next case, 537, Mabane and Schaefer versus Donos. On behalf of the objectors, I have attorney Andrew Finko,
Hello, Andrew Fenko for the objectors.
FINKO. Is anyone here on behalf of candidate Donos?
Yes.
Yes.
The candidate is here in Springfield, Marnie.
Oh, thank you. Okay, that is the same candidate as 532.
Correct.
Thank you. Next case, 538. I need everyone to please stop speaking in here. Thank you. Joggerist versus Atkinson. I have an appearance on behalf of objector by attorney John Fogarty. And it looks like someone is here on behalf of candidate Atkinson. Thank you, sir. Case 539, Jarrett and Johnson versus Marceline. I have an appearance by objectors. On behalf of objectors by John Fogarty. Is anyone here on present on behalf of candidate Marceline? No one in Springfield, candidate Marceline?
No, ma'am?
Thank you. Case 540, Cabello and Wright versus Tover. I have an appearance on behalf of objectors by John Fogarty. I think we know how to spell his name at this point, hopefully. Yes, I'm getting the nods and the heads up. And Mr. Katover is here as well. Next case, 25 SOEB GP 541. Hayleitner, Thurl versus Holt. An appearance for objectors by John Fogarty, and candidate Holt is present as well.
Present.
Thank you, sir. Case 542. I'm gonna botch this name. Eichscheid and Halsey versus Edwardson. Is anyone here on behalf of the objectors?
Yes. John Fogarty.
Thank you, sir.
How are you?
If you haven't appeared, please make sure you do. Maybe you didn't, it just didn't make it onto my sheet. And is anyone here on behalf of candidate Edwardson? Anyone in Springfield, candidate Edwardson?
No, ma'am.
Thank you. Case 543. Cianci or Cianci and Africano versus Ellington Snipes. An appearance by objectors for John Fogarty. Can you pronounce your first client's name?
Cianci.
Cianci. Okay, I got it wrong both times. Okay, thank you. And is candidate Ellington Snipes present? Candidate Ellington Snipes in Springfield?
Nope.
Okay. Case 544, Oriema, Hines, and Bayless versus Doozer. John Fogarty on behalf of objectors. Is candidate Doozer present?
By Max Solomon here.
Oh, thank you, sir.
filed appearance on that
Oh, you did. Okay, I'm seeing it right now. Sorry that the type is really small and it's really long, so my eye is slightly failing me at this moment. Thank you, Mr. Solomon.
Thank you. Yeah.
Next case, 545, Bell and Bell versus Carter. Appearance for objectors by John Fogarty. Is anyone present on behalf of candidate Carter?
I'm present. I'm the candidate.
Candidate is here in Springfield, Marnie.
Thank you, candidate Carter.
Thank you.
Just check with.
Next case, 546, Christ and Stevens versus Tejeda. Appearance for objectors by Mr. Fogarty and is, looks like an appearance by attorney Abbasi for the candidate.
Correct.
Yes.
And again, that's ABBASI, correct? Case 548, Jones versus Ortiz. I have an appearance on behalf of the objector by attorney Ed Mullen. And on behalf of candidate Ortiz, Mr. Abbasi.
Yes.
Case 549, Grace Stewart versus Russell. Is anyone here on behalf of objector Grace Stewart? Anyone in Springfield on behalf of objector Grace Stewart?
Nope. We have no more down here.
Okay, thank you, good to know. Okay, well, it does appear that objector Grace Stewart has filed an appearance and has been
Grace?
served, but is not present.
Grace Stewart?
Grace Stewart. Grace hyphen Stewart. So if the board does want to entertain the option of dismissing this case for want of prosecution, it can do so now, or we can wait until the December 9th meeting to see if objector Grace Stewart has appeared by then. Does the board have
Oh, I just give her a chance. I hold off. We'll do it tonight.
Sounds good. Thank you, Madam Chair. Anybody who is in conference room D, whose electoral board case has not yet been called, you may want to migrate into this room now. But anyone who's here for campaign disclosure, it's still going to be a little while, and feel free to keep hanging out in conference room D. Case 550, Ortiz versus Aquino. Appearance by Mr. Abbasi on behalf of objector and on behalf of candidate Aquino, Heather and Adam Falk. 551, Slattery and Roche.
You want to sit down?
Versus Badgett. So I have an appearance on behalf of objectors or objectors present. And ma'am, what's your name?
Catherine Slattery.
Thank you. And is the other objector Roche or Roche present?
Roche, he's not here.
Roche is not here. And is anyone here on behalf of candidate Badgett? Okay. 552, March versus Keating. I have an appearance on behalf of the objector by Mr. Abbasi. Is anyone here on behalf of candidate Keating?
Yes, Attorney James Tunick, Tunick, on behalf of candidate Keating. And I filed my appearance through the general counsel email. Should I tender it there?
If you, I'm sure it probably exists somewhere in our email box, but bring it down to your hearing officer just in case they don't have a copy yet. Great, thank you. Case 553, Rice versus Solomon and Young. An appearance on behalf of the objector by Mr. Abbasi. An appearance on behalf of the candidates by Mr. Solomon, who is right next to Mr.
Candidate
Abbasi.
here. Morning.
Yeah, thanks, Solomon.
Case 554, Anderson versus Tillman and Mosley. I have an appearance on behalf of the objector by Attorney Morphew, who I understand is downstairs. And on behalf of candidate Tillman and Mosley, I heard one person is here.
Tillman.
And is Mosley present?
Yeah.
Okay, thank you.
What was that other attorney name?
Kevin Morphew, Morphew. And he is downstairs somewhere with the hearing officers. So if you proceed to conference room D, at some point they will match you up with him and your hearing officer.
Thank you.
Case 555, Lipinski versus Dombrowski. I have an appearance on behalf of the objector by Mr. Abbasi. Is anyone here on behalf of candidate Dombrowski? 555, candidate Dombrowski? No.
None here.
Case 556, Abbasi versus Shepherd. an appearance on behalf of objector by Mr. Abbasi. And on behalf of candidate Shepherd, I have an appearance by Kyra Pouladakis.
Hi, Attorney Kyra Polidakis here on behalf of Joe Shepherd, last name Kolidakis.
Thank you, ma'am. Case 557, Jones and Garza versus Swan. Is anyone here on behalf of objectors Jones or Garza? Bear with me for 1 second while I check on the status of service. It looks like candidate Jones has been, or excuse me, objector Jones has been served. But objector Garza perhaps wasn't. So I think we'll hold off on that case. In doing any dismissal for a want of prosecution. On behalf of the candidate, we have the candidate himself, Mr. Swan. Thank you, sir. Case 558, Jones and Garza versus Williams. We just called them, so we'll hang out until December 9th to see if Jones and Garza appear. And is anyone here on behalf of candidate Williams? 558 Williams. No one. Thank you.
First name, is it Anthony?
Yeah,
Is it Anthony?
I don't have it in front of me. Let me take a look. 558. I don't have that in front of me, but if you want to talk to some of our staff, if you're concerned that it's you, feel free. I don't have a way of looking it up right this moment. Oh, here we go, Anthony Williams.
Yeah, I'm here.
Okay, thank you, sir. Sorry about that. Next case, 559, Abbasi versus Williams, an appearance by Mr. Abbasi. And is this the same candidate, Williams?
Yes.
Yes, thank you, sir. Objection 560, Jones and Garza versus Shepherd. Jones and Garza are still not present. And candidate Shepherd by attorney Kolidakis. And one more time, if you don't mind spelling, just to make sure the hearing officers got it.
Attorney Kyra Polidakis, last name Kolidakis.
Thank you. 561, Abbasi versus Palmer. I have an appearance by Mr. Abbasi on behalf of objector. Is anyone here on behalf of candidate Palmer? 561, candidate Palmer. No one. 561, Jones and Garza versus Delgado. No one is here on behalf of Jones and Garza. Is anyone here on behalf of candidate Delgado? No one. Case 563, Abbasi versus Delgado. Mr. Abbasi is present on behalf of himself, or his brother, I should say, and candidate Delgado is not present. 564. Did I already call 564? Okay. Jones and Garza versus Palmer. We've established Jones and Garza are not present. Is candidate Palmer present? All right, so no one on this case. 565, Walls versus Sims. On behalf of objector Walls, we have Mr. Fogarty. Is there a game today? Is that the Cubs hat?
Bears.
Bears.
Sunday.
You see how much I know about the sports.
You got the team right.
They're in first place.
Oh, excellent. Good to know. And on behalf of candidate Sims, I have Heather and Adam Vaught. 566, Gordon and Mock versus Russell. On behalf of Gordon and Mock, Mr. Finko.
Andrew Finko here for the objectors.
Finko. And on behalf of candidate Russell, I have Mr. Ladazinski. I think I saw you.
Steve Ladisinski, LADUZISKY.
Thank you, sir. 567, Gordon and Mock versus Cowley. Mr. Finko again on behalf of Gordon and Mott. Is anyone here on behalf of candidate Cowley?
Scott B. Erdman, ERDMAN, on behalf of the candidate.
Thank you, Mr. Erdman. 569, Pappas versus Pierce. Is anyone here on behalf of objector Pappas?
Yes, good morning, Daniel Olswang, last name spelled OLS, Sam, WAN.
Thank you, sir. And on behalf of candidate Pierce, we have Jeffrey Meyer.
Correct.
Thank you, sir.
Sir.
570, Suitors versus Brown. Is there anyone here on behalf of objector Suitors?
That would be me again, Daniel Olswang, OLSWAN.
Thank you, sir.
Max Solomon on behalf of candidate SOLOMON.
Wonderful, thank you. Case 571, King versus Maxwell. I see we have an appearance by Kelly King as the objector. Here. Thank you, ma'am. Is anyone here on behalf of candidate Maxwell?
Yes, Christian Maxwell here, I'm the candidate.
Thank you, ma'am.
Thank you.
Bear with me for 1 minute. It looks like I'm missing a sheet. Okay. Okay, so it looked like Levitt versus McComey, 25 SOEB GP 107. It looks like the objector Levitt has not yet been served. And on behalf of candidate McComey, we have Mr. Fogarty, who appears to have left us. Levitt versus Chesney is the final case, 25 SOEB GP. Candidate, objector Levitt is not present, and we have Mr. Fogarty on behalf of candidate Chesney. So congratulations, we've called all the cases for electoral board. If your electoral board case has been called already, 1 second, Mr. Brett, please proceed to conference room D. And Mr. Brett.
We believe that you called Levitt versus McComey and Levitt was Chesney earlier, and Mr. Levitt was here.
Oh, did we? Okay, thank you. My mistake then corrected. I already called 107 and 108, and they were both out of order on my agenda, so good to know. Levitt is here, Fogarty is here, and we mistakenly called your case twice.
Oh.
So,
Yeah, quite all right.
excellent. So feel free to head to conference room D.
Okay, and what happens at conference room D?
So for anyone who hasn't proceeded there yet, that is where you will wait to meet with your hearing officers.
All right, thank you so much.
Thank you very much. And Madam Chair, are we ready to move into withdrawals?
Absolutely. We'll go to, the agenda number 4, objections, candidates withdrawn. Do you need a motion or what do you need from us, Marnie?
So we have one withdrawal that requires board action today to dismiss the associated objection case. I wanted to let everybody know that additional withdrawals have been received recently. So I anticipate a number of withdrawals will be on the board's December 9th agenda. The one we have today is Proctor versus We Met, 25 SOEB GP 513. I wanted to let the board know the agenda mistakenly lists this as an objector's withdrawal of their objection petition, but is actually a candidate withdrawal of their nomination papers. Is there a motion to dismiss case number 25 SOEB GP 513 due to the candidate's withdrawal?
So moved.
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballarcroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right, Marnie, do you want to discuss the rules of procedure for the State Officers Electoral Board?
I do have an introduction. So pages 32 to 51 of the SOEB packet include draft rules of procedure for these proceedings. So in addition to updating relevant dates, there are a couple of small changes from our 2024 rules of procedure that I wanted to point out to the board. First, these rules incorporate the use of the new petition and objection portal for the filing and service of documents. Second, these rules in Rule 8C include more detailed procedures on the process for enforcing subpoenas. And then finally, Rule 11B has been updated to provide that the standard of proof for a pattern of fraud case is by clear and convincing evidence. The standard comes from the case of Bass, B-A-S-S, versus Township Officers Electoral Board for Rich Township. That's case 2025, IL App First 250092. So if there are any questions about the rules, I'm happy to answer them. But if not, I will wait for a motion to formally adopt the rules of procedure on page 32 to 51 of your packet for objections to nomination papers of established party candidates for the March 2026 general primary election.
There discussion? Do I have a motion?
So moved. To adopt the rules.
Do I have a second? It's been moved and seconded. Amy, roll call, please.
Ms. Bellancroft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Present.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right, next, we need to authorize our general counsel to appoint the hearing officers as required by law. And you have received that in the mail or in your email. They're all noted here and the cases attached to them. Marnie, do you need to discuss or shall we have a motion?
I wanted to let everyone know we have 3 new hearing officers this year, which is quite exciting. All 3 attorneys have experience as hearing officers for Cook County and or the Chicago electoral boards and come recommended by our other hearing officers. Their names are Linda Crane, Chris Agrella, and Kevin Bry. I also wanted the board to know that our hearing officer and former board member, Ernie Gowan, has recently retired, so we will miss him this year and going forward. So as detailed, I'm sorry.
No, I was just going to say absolutely. So, but go ahead.
Thank you. So as detailed in the memo distributed to board members and posted on our website yesterday, I request the general counsel be delegated authority to assign hearing officers to this matter. The initial hearing officer assignments are listed in the memorandum, and please note that under Rule of Procedure 5C, a hearing officer may be removed from a case if an administrative need arises, or alternatively for good cause shown. I'm happy to answer questions, or if there are none, a member can make a motion to delegate to the general counsel the authority to assign and reassign, if necessary, hearing officers to these cases.
I move that we delegate to the general counsel the authority to assign and reassign.
Second. Been moved and seconded. Amy, roll call, please.
Ms. Bellancroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right. Do we have other business within the electoral board? Marnie, Bernadette? No? Do we have comments from the general public? All right. Do I have a motion to recess the State Board of Elections until December 9th, 2025 at 9 a.m. Or until the call of the chair. Do I have a motion to that effect?
Madam Chair, if you could amend your motion to recess the State Officers Electoral Board, not the State Board of Elections.
Sorry about that. State Officers Electoral Board.
So moved.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellarcroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yeah,
Chair Donahue?
Yes.
Motion passes.
All right. Um. We need to now, reconvene as the State Board of Elections. If I could have a motion to that,
So moved.
second? Been moved and seconded. Roll call, Amy.
Ms. Bellarcroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
yeah.
Chair Donahue?
Yes.
Motion passes.
I am sure we all want to keep going. Marty, do you need 5 minutes or anything?
I do, I need a break, please.
I wouldn't surprise me. So let's take 5 minutes.
Thank you.
Are we all back and ready to go?
There's some.
Oops,
She got the microphone.
got
it, but I can't hear.
Can you
you're
hear me,
muted.
Madam Chair?
There we can. There we go. All right.
Thank you.
We're back in business. We have reconvened as the State Board of Elections. We've taken a roll call, right, Amy?
We did.
So we will have the report of the General Counsel. Please, Marnie.
Thank you, Madam Chair. So I'm going to start with agenda item 5A. It's a motion for reconsideration. 5A1, SBE versus Friends of Juan Moreno. The case number is 25 AM 67, and I have appearance on file for the committee. I'm going to read my recommendation before the committee will be able to respond. So here I am going to recommend denying the motion to reconsider, but I do think there's a very reasonable settlement that can be had with this committee. So please bear with me. The committee filed a motion to reconsider $21,151.80 in civil penalties against respondent for late filing of 15 A1 reports in March 2025. The fine equals the full amount of the contributions. Following a final order issued at last month's meeting, the committee timely filed this motion to reconsider. Under Rule 125.440D, a motion for reconsideration may be granted only if the board determines that the reasons the respondent failed to submit an appeal in a timely manner are outside the control of the respondent or otherwise extraordinary, and the basis for the appeal is meritorious. Here, the committee says its mailing address changed, and that resulted in delayed delivery or misrouting of critical notices. Here, it's my recommendation that the committee's change of address was not outside the committee's control, so I recommend denying the motion to reconsider for this reason. However, even if the board determines that the mail delivery issue was outside the respondent's control or otherwise extraordinary, the committee has not demonstrated its basis for appeal is meritorious. The committee says a transition in its record keeping and compliance responsibilities earlier this year created temporary confusion as to who was responsible for submitting A1 filings and responding to board communications. The committee says it acted in good faith and the violations were not intentional and that the penalties are disproportionate to the offenses. Finally, the committee says these are its first violations, which is inaccurate. The committee already had a previous fine balance of $750 for these 15 violations, and the committee has not offered any evidence that appeal is meritorious. So in sum, I recommend denying the motion to reconsider because the committee's failure to appeal was not outside its control or otherwise extraordinary under Rule 125.440. And even then, the committee has not demonstrated the basis for its appeal is meritorious. I will note, however, that this committee's balance is only about $2,800 and it cannot pay a almost $22,000 fine. So that's something we can talk about after the committee has an opportunity to comment on my recommendation.
Committee, if you would speak, I don't have a name. Is it Juan Moreno?
Oh, did Mr. Moreno not appear? He had filed an appearance.
He did.
He did file an appearance.
For Chicago.
Oh, it's for Chicago.
Okay, well, Mr. Moreno is not here, so my recommendation is to deny the motion to reconsider, and I'm sorry I read that whole recommendation.
Oh, I thought you said there was somebody up there, so I didn't stop you. All right, so do we need a motion?
Yes, we need a motion to deny the motion to reconsider.
So moved. Second? Do I have a second?
Second.
It's been moved and seconded. Roll call, Amy.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, next up is settlement offers in 5A2.
Thank you. SPE versus Vernon Township Republicans. I do have an appearance on file. Who is present for Vernon Township Republicans?
Yes.
John Fox,
FOX?
FOX.
Okay, and what is your role in the committee?
I'm the treasurer.
The treasurer. Okay, excellent.
I'm the culprit here.
So I will read my recommendation and then, sir, you'll have the opportunity to address the board. So the committee is offering $375 to settle a $750 fine. So that's 50% for late filing of the September 2024 quarterly report. The offer meets the 50% standard, but falls short of the balance and receipt ratios at 9.19% and 18% respectively. The committee is considered low dollar, but 50% of its last reported balance of $5,672.28 would be more than the original fine. The committee says that it's volunteer only and runs on a shoestring budget. Here, I recommend rejecting the offer because although it is for 50%, the balance and receipts ratios weigh against acceptance under the board's settlement factors, and low dollar treatment does not benefit the committee here.
Thank you, Marnie. Mr. Fox?
I'm just really kind of here as a appealing. I don't, the fine seems very arbitrary. I don't understand where the fine comes from.
All of the fines are calculated based on the Illinois Administrative Code, Title 26, Section 125.425. So you can consult that section and it will tell you exactly how all of the fines are calculated.
So the committee isn't going to care that we're volunteer, that we do this for out of the good of our hearts, and we try to. I spent, as I said, things were so screwed up when I got involved. I went back 3 years to try and get things straightened out, to amend all the files. I think from what I've seen, there's just a lot of committees that don't even do anything properly here. They don't even file their reports. And the fact that we're trying to do things properly and maintain a standard, I think that's important. So the fact that I'm paying the $750, that's why I'm saying, what $375 would be a fair settlement in my mind. So, I mean, from what I talked to, I forget who the gentleman is down in Springfield, Tom, somebody said that many organizations don't even file their reports. It's a joke. So we're just trying to do our job, do it properly. And I don't know, have we been late ever in a long time?
I could take a look.
I mean,
not making.
I think that's important for the integrity of our organization, that to just try and do things properly and abide by the standards. So, and initially, I think they said we had $22,000 in our account. We've never had $22,000 in our account, but it was so screwed up over the years. I've tried to bring it back in line. Now it's down to the penny with what we maintain in our bank account. So it's a stiff penalty for a company that runs on $800 a month.
If Mr. Newman down in Springfield,
Yes.
He is.
Mr. Newman, are you able to tell from your records whether this is the committee's first offense?
It would not be the first offense. If it had been the first offense, the penalty would be stayed. So there was at least one previous penalty that was paid, although I don't have the details of that.
Thank
And
you.
Mr. Newman, I have a question.
Hang on, we have a question down here.
Mr. Fox said that they have never had like 2,200 in their account. Oh, 22,000. Okay. I'm sorry, but I showed that they have roughly 8,000 currently. Is that right?
No, the top number would be the current one. So
So
5,000.
5,000. They have $5,672.
Correct.
Okay, thank you.
So it takes us all the effort in the world to get to $5,000 to run $800 a month. So $750 is a big penalty. Especially I'm paying it. You guys want to help me out?
I assure you that our oversight and committees do in fact file properly. And if they don't file properly, that's what we're here for. So, do I have a motion on Mr. Fox?
Well, what, can I ask one more thing? What happens to the people that don't do things properly and they don't report? They don't even get involved. They don't, which is repeatedly what I've understood from Tom.
They are also fined under 26.
And you ever see the money?
Illinois
Do they ever come out?
Code
Do they ever-
125.425.
Do they ever, the guy that just owed $22,000, what was that all about?
I don't know what matter you're talking about, sir, and I can't talk about
The one
other
Friday,
matters. We're
one
here to
Friday.
talk about your matter only.
Do I have a motion?
The recommendation is to reject the $375 offer because the balance and receipts ratios weigh against acceptance under the board's rules settlement factors, and low dollar treatment does not benefit the committee here.
Let me ask.
I have a
before we-
question.
Catherine?
Do we know what amount would satisfy at this
Yeah.
point? Because I'm sorry, who's representing the committee again? I can't see you, so I don't know.
John
Mr. Fox.
Mr. Fox, we are bound statutorily. We don't have a lot of wiggle room here. And so I understand what your point is, but to say that committees violate all the time and they're never brought to task is untrue. So my question to you, Madam General Counsel, do we know what amount would satisfy the ratios here? Or can we make a ruling today and send Mr. Fox away to work with our staff to figure out what that amount looks like?
That is not something, we cannot change the ratios. The ratios are based on how much money the committee has had over the last year. So those numbers right now are going to be static. So right now, because the committee has $5,672 and has had amounts that are in at least higher amounts over the last year, to ask for a $375 settlement of a $750 fine is not going to put the ratios within our 50% or above guidelines.
So are we saying here that Mr. Fox has to pay the whole $150 or $750 fine in order to satisfy our statutory requirements?
I mean, this is up to the board to decide. So the board does have some leniency under the statute. Would you like me to go to the statute and read the factors that ought to be considered? Would that be helpful?
Can I,
No, I'm familiar with them, but if anybody else needs that, that's fine.
can I interject for a second?
It's up to the chair.
Yes, Mr. Fox.
There's two things at stake here. One thing, they said that we didn't file our D1s correctly. I was never really aware of the D1s. We changed the president and treasurer online on the site. I guess there was a report that needs to be filed. I was trying to do that last night. I could probably work with somebody here to figure out. I don't really understand the form. Secondly, we've got a fundraiser Thursday. We were trying to do a raffle and they were holding out on the raffle until this is settled. So I'm hoping this gets settled and then we can get our approval for the raffle for the fundraiser Thursday evening. What if I pay so much per month for the next 7 months or something? I mean, the next 3.5. Assuming I'm getting the 375.
If you have
Unfortunately,
five,
the fine has to be paid within 30 days.
Oh, the whole fine?
Yes.
what is the problem with the fact that you have $5,000 plus in your account?
I feel responsible, want to pay it myself and not penalize the organization. So I guess that's between us.
Mr. Fox, if you want to make another offer to pay the $750 fine today, I think we can resolve this and you can move on to doing your fundraising as you would like to.
So you want the entire amount?
Oh, just to clarify, if the committee is going to pay the full $750, we would just be denying the settlement offer. There's no need to offer $750 because that's the amount of the fine. So I don't know if the board is willing to entertain an offer somewhere between $375 and $750, or if the board would like to just reject the settlement offer.
How about 500?
All right, it sounds like Mr. Fox is increasing his offer to $500.
$500 offer, there you go.
Do I have a motion?
I make a motion to reject the settlement offer, but to accept the $500 settlement offer that was just tendered.
Second that motion.
Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Cray?
Yes.
Mr. Nevezi?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Abstain.
Ms. Watson?
yes,
Vice Chair Turbin?
Yeah.
Chair Donahue?
Yes.
Motion passes.
Well, never mind.
Madam Chair, right?
yes.
May I call the next case that has an appearance on file?
One question.
Yes, please.
So who do I make a check out to and how do I get it resolved today?
You can consult with Mr. Nauman right there behind you.
Okay. Thank you.
I hope you never come to us again, Mr. Fox.
I love you guys.
No, yeah, I'm afraid,
Thank you.
okay.
The next one, the parents.
The next one where we.
Next order of appearance is Citizens for Assad Khan.
Nope, number 5.
Correct.
Number 5, that's right. We had a new one here. Senate 5A, please.
5A6, correct?
5A6, sorry.
Okay, the case number is 25 AM 86. We do have an individual here on behalf of the committee, but first I will read my recommendation. My recommendation here under the current settlement amount is to deny the offer. However, if the offer is increased by $263, then my recommendation would be to accept the offer. So I'll give a little bit of an explanation. There is a corrected offer sheet here on page 34 of your packet. So that is the offer sheet to take a look at. Here, the committee is seeking at first to have its fines waived, but failing that is making a settlement offer. The waiver request is based on these violations being its first group of fines. I do not recommend granting a waiver as it deviates from the board's usual practice, and there's no particularly compelling reason for a waiver under the factors in section 9-10G. I think this case is more appropriately handled through the settlement process. So if no waiver is granted, the committee is offering $1,000, which is 33.33%, to settle $3,000 in fines for late filing of 3 A1s during the first quarter of 2025. The offer is below 50%, but compliant in terms of balance and receipts ratios. The committee is considered low dollar, but 50% of its current balance of $2,526.50 would be $1,263, which is more than the $1,000 offer made. So that said, I do think it would be appropriate here to consider the fact that the committee's current balance is not sufficient to pay the fine. And here I would recommend accepting actually, I take that back, that there is enough money to pay the fine. So strike that statement. But here I would recommend accepting the offer if it is increased from $1,000 by $263 to $1,263.
No.
And Madam Chair, is it okay to allow the committee to speak?
Yes, is it? Okay, that's what I was thinking. I was confused. All right, yes, 5A6. Yes, please speak, sir.
Yeah, hi, my name is Asad Khan here, and this is a first time technical error. Reporting is not easy, by the way. Sometimes the system doesn't work. And our accountant tried to do that, and the money we received it was right at the time, a few days before the election. So you know how busy they were. So they tried to report it. The whole money was reported for sure, but there is a form which we're supposed to submit with it, which is called 57 something. That was not submitted, and that's why they're fining us. And this is a first time error. And the money which we have in the back, we still have to pay, I think, the printer or something like that. And that's why we were requesting if you can do a waiver because of the first time error. And I would humbly request that. You know, and if you cannot, then at least don't fine me that big amount, you know, reduce it a little bit. And I'll pay today and move on.
Is it the first offense?
It is,
Marnie?
yes, ma'am.
Bear with me for 1 minute. I will take a look. Because it would probably be stayed if that were the case, but let me take.
It is the first one.
Marnie, I can offer, it is the committee's first violation, but there are three A1s involved from different dates, so therefore it would not be a state penalty.
Thank you.
All right. Do I have a motion?
Or is the committee willing to increase its offer by $263?
Requesting a waiver, you're not getting it, or it's not,
This is the board's decision to make.
it's a first time error, you know, everybody gets that. I mean, you know, we've never done anything like this before. So I'm requesting the board to look at that and grant me this waiver. I've never been in this office in my life. It's the first time. And humbly requesting, you know, somebody take a move on it and say, okay, it's a first time error. And you have the authority to do is just waive that. You know, and I am requesting some of the board members humbly, so, you know, please make a motion on it. And let this waiver be accepted.
Well, I think, sir, that under our standards, we don't count that as a first time error because you have the second and the third A1 that was also not filed. So even in your mind, you understand it to be the first offense. The way our system uses it over the years, this actually is not a first offense. If it was a first offense, then what we would do is we wouldn't necessarily grant a waiver, but we would stay in position of compliance. So that would be what you'd be requesting instead of a waiver. I know that's not what you have requested. However, even if it was what you requested, our usual practice would be to deny that as well. So while I can't speak for all members of the board, if we are consistent with how we handle cases like yours over the years, we would deny the motion for your request for a waiver, and then we would proceed on the settlement offer.
I'm not.
So
I'm not
with
sure.
that, I would move that we deny the request for a waiver.
I'll second.
Discussion? None? Roll call, Amy?
Ms. Ballard Croft,
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
I move also that we deny the settlement offer. However, we invite the committee to make an offer of the increased amount. Forgive me, it's an additional $263.
That's correct, for a total of $1,263.
Can I pay 1,200 and get it over with today?
The amount would be $1,263. $1,263.
That would be, as the committee is low dollar, half of its current balance would be $1,263.
Right. So to be clear, sir, if we treated your situation the same way that we treat everyone else that it comes before this board, we would be likely to accept the settlement offer of $1,263, and you could pay that today and be done with it.
Okay, let's get it over with.
Okay, I move.
Second that motion.
It's been,
All right,
it's been moved and seconded to accept a settlement offer of $1,263. Roll call, Amy.
Ms. Ballard Croft?
Yeah.
Was that a yes?
Yes.
Yes, that was.
Thank you. Sorry. Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right, we need to go back to 5A5. Friends of Jessica Franks. Are you with me, Marnie?
Yes, someone is here on behalf of the committee.
Yes, ma'am. Jessica Franks is here in Springfield.
Okay, excellent. Well, I will read my recommendation before candidate Franks addresses the board. So this committee was administratively closed in September 2025, and the candidate says the committee never raised or spent $5,000, but the committee also never filed a quarterly report after filing its D1 statement of organization. Here, the committee is offering $300, which is 10%, to settle $3,000 in fines for failure to file the March, June, and September 2024 quarterly reports, as well as the March 2025 quarterly report. Here, the ratios are unfavorable because no quarterly reports were ever filed, and the committee is presumably low dollar, however. Under section 9-10G of the election code and under rule 125.450C, the board is meant to consider whether the political committee made an attempt to disclose the contributions and any attempt made to correct the violations in determining whether to reduce civil penalties. Here, considering the committee has never disclosed any of its financials, I recommend rejecting the offer. However, if the committee files all of its quarterly reports and a proper final report, I would be more inclined to consider the offer.
Are you saying that the committee never filed anything?
The committee filed a D1 statement of organization, and that was it, and that was all. And then the committee was administratively terminated because it wasn't filing reports.
How do you mean administratively terminated?
So if a committee just stops filing reports and isn't responding to our notices and our fines after 1 year under our rules, we can administratively close the committee. So that's what we do for committees like this who ignore us for a year and a half.
And they just went on collecting money or do we even know that?
We have no idea.
All right.
Never filed any sort of financial statement with us.
All right. Well, we have Ms. Franks here, so we'll ask here. So Jessica Franks, if you wish, speak into the mic, spell your name and identify who you are and where you come from.
Jessica Franks, Franks, and I'm from Christian County, from Taylorville, Illinois. And I ran for circuit clerk a couple of years ago, and the only fundraiser that I ever had was a gun raffle. My county chairperson told me I was required to open this to be able to have that raffle. And then whenever I started getting notices and all this and that, he said, don't worry about it, because if you don't spend $5,000, you don't have to do any of that. So I never did. And then whenever I got the first notice, I think it was like $700 and some dollars was the first penalty, $750 or something. I took it straight to him and he said, no, they'll see after the election's over and they realize you didn't win, they'll close it out because you didn't make that. And so I should have probably just brought my bank statements to show you what came in, but I think I was right around $2,100 is all that I ever brought in. And that was just to buy signs. So I'm sorry, I laugh because I'm nervous because I'm
No.
hearing all this.
No,
and,
you're just fine and we don't buy.
yeah.
Except if, no. Do you intend to run again in the future?
No, I was running for precinct committee, and the only reason I want to do it is because I didn't like that I was given incorrect information to begin with. I felt like if people that were in those positions had given me the correct information, I wouldn't be sitting here right now.
Well, that's
so I would like to be able to stay on, but with a fine that big, I wouldn't be able to pay it in time to stay. So.
Are you paying the 300 out of your own pocket?
Mm-hmm.
I didn't hear the response to that.
Yes, I'm sorry.
It's
She's paying the 300 out of her pocket.
Yeah.
Is what she said.
Thank you.
And you are a precinct committeeman as we speak?
I'm appointed and I was going on the ballot to be able to vote.
If, am I correct in saying that if she waits 2 years, that the fine and doesn't go on the ballot, that the fine goes away?
No, because
But
she
then if
never,
you come back, then you have to, yeah.
because
yeah.
she never filed any financials and she never filed a final report, the fines will never expire unless all the quarterly reports are filed and a proper final report is filed.
Can
And
she
then it
do that
goes-
now, Marnie? Can
And
she
then
file
that goes
those
away.
reports?
I'm sorry, there were two people talking.
Go ahead, Catherine.
Can she file all of the necessary reports now and see where we're at?
Yes,
Because if she only raised $2,100 total at some point, I don't know why she has to file to begin with.
Because she already filed the D1. Once you file that D1, you have to file. If you
Oh,
wouldn't have
I got
filed
it.
the
I got
D1,
it. I hear,
I was told I didn't even have to
All
do
right.
it to do the raffle.
So what we could do, Tom or staff could help walk her through what she has to file, and then it's a moot issue?
well,
still have the fines.
so if she files all of the back quarterly reports and files a proper final report, then there are two options. One would be to come back with a settlement offer. The other would be to keep the committee closed for 2 years following the final report and any imposition of other fines, should there be any. And then after 2 years after that, so long as the candidate does not open any other committees, then the
Yeah,
fine
no, that's,
expires.
no, we go on. What is, what's the total fine now?
I'm sorry, I'm having a lot of trouble hearing. If people could speak
What's
up.
the total fine now?
The total fine is $3,000.
Oh, geez.
I mean, I'm leaning towards suggesting, Ms. Franks, that you file the necessary reports and we see what's what after that. I mean, to my mind, that's the most logical first step to take, is to work with staff to get those reports filed.
Chair, how long ago was this happened?
Well, it was closed a year ago, but yeah.
So we just only have a year to look back on, is what you're saying, and basically.
So the missed reports are March, June, and September 2024, and March 2025. Tom, do you have information about December 2024? I'm sorry, we can't hear you.
I hadn't said anything yet, sorry.
Oh, sorry.
No, I don't. In looking through the records, somehow that one just missed being assessed.
Okay,
So yeah, that would not be part of it.
okay, thank you.
Question, General Counsel. Ballot.
Go ahead, Jack.
Ballot forfeiture applies to a political position like precinct committee person as well, correct?
Ballot forfeiture would apply if you're trying to run for an elected office. I believe, did Ms. Frank say it's an appointed office?
Well, she's been appointed to a precinct committeeman, but she's on the ballot to run in the next election.
I mean, Tom, correct me if I'm wrong, but I believe there would be ballot forfeiture.
Yeah,
That's correct.
yeah.
So I think, Ms. Franks, there's some house cleaning that you're gonna need to do, because you might not even be able to run unless you do this, is my understanding of it. Am I correct in saying that, Tom and Marnie?
Yes.
Yes, she will be removed from the ballot if these fines are not taken care of in some manner. In that case, I would say that if she does file all of the reports, she should come back with a settlement offer, because leaving the committee closed for 2 years to expire isn't going to help her with the ballot forfeiture issue.
No.
So the logical next step forward is to file all the quarterly reports, file the final report, and then come back with a settlement offer.
Would that be able to be done before I had to forfeit?
Yes.
Okay.
So I'm gonna make a motion to deny the settlement offer based on the general counsel's recommendation.
Second.
Roll call, Amy.
Ms. Bellicroft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson? Ms. Watson, you're muted.
Still muted.
Ms. Watson?
Yes, sorry.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you. for
Yes.
coming in.
They're losing somebody good.
I'm sorry, we can't hear you.
All right, next up is, do we keep going with appearances and go down to 5A11?
We have several appearances before 5A11.
Okay. Oh, I don't have them.
I don't have.
Sorry.
I don't have.
The next one that I have is on agenda item 5A7. Democratic Woman of the Southland Region, 24 AJ 35. Is someone present on behalf of that committee?
Not here.
Not here? Okay, then we'll skip it. And can come back for a vote. So we have two cases left on which I have appearances. One is Mr. Casper's case, which I'm guessing is going to take a few minutes. So it's up to the board whether we want to call 5A11 first, because that should be short, or if we want to call 5A8 first.
I would go with 5A11 and
Okay, so this is SBE versus Friends of Ralph Stock. This is case number 25 AM 54. There is someone here on behalf of the committee. However, the person checked an other box of who they are. So if you gentlemen could introduce yourselves and spell your names.
I'm Ralph Sock, SOCH. I'm the chairman of the.
Okay, in that case, yes.
All right, and my name's Tom Phelan. I'm a former trustee in the seat that he currently held, and I was just here to offer some insights into the situation because he's relatively new.
Okay, so because you're not his attorney, sir, you're not able to speak for him. But Mr. Sach, you are able to speak for yourself after I've read my recommendation.
Okay.
The committee is appealing a civil penalty of $500 for the 48-day late disclosure of a $5,000 contribution and a civil penalty of $1,000 for the 26-day late disclosure of a $1,500 contribution, both in the first quarter of 2025, for a total of $1,500 in fines. These are the committee's first and second violations. The candidate said his 2025 race was uncontested and he had little campaign activity and forgot to file the A1s. Here, I agree with the hearing officer that the appeal should be denied for lack of a statutory basis.
all right. Go ahead, sir.
I'm new to this whole thing and I had put those numbers in the form, but I must not have hit the button that there's a different button for the hit to submit. The numbers were in there and they got submitted with my quarterly report. It's my first offense. I've only been in this role a few years. I've got $6,000 in the account. It was unintentional. It won't happen again. I found out Tom, who I took the role over from, has helped me get acclimated to the system. So there was no malicious intent. I didn't forget. All my quarterly reports are filed on time. That was just an error on my part. And plus I didn't know about into the election that it had to be reported around that. These are the first two donations I ever had over that amount that had to be reported since I opened the account. So that was it.
And I'm not speaking on his behalf, but this ironically happened to me, this exact same thing 15 years ago. And mine is more of a request that I did 15 years ago for the system, because when these reports, these special reports that need to be submitted, all I suggested 15 years ago is that report due thing on the bottom that he's referring to, maybe light up yellow or red. Because, and I think our clerk is having the same problem as we're speaking. If not the software itself being modified so that when someone does, as he said, I do believe he did report when it was received, he just didn't hit that special report due button. If the software could be modified to recognize when a contribution, exceeds a threshold within a certain time period, that it just automatically reports it. And that was my only reason for showing up here. I do, Mr. Sock is a sincere guy. There was no malicious intent, and it was the same cycle, and it was an uncontested election. So I don't want to repeat what he was saying, but ironically, it happened to me 15 years ago, the same exact thing. And I think for the same reason, I had just forgot to hit the special report due. And we know that ignorance is not a defense, but thought we'd come here and try to pitch this case in.
Yeah, and again, all my reports have been filed on time. I've never missed anything. I'm really diligent. So I apologize. Thank you for hearing me.
Further discussion? Do I have a motion?
The
I make a
rec-
motion.
I make a motion to accept the recommendation of the general counsel and deny the appeal.
Second.
It's been moved and seconded. Roll call, Amy.
Ms. Bella Croft,
Yes.
Ms. Craig?
Yes.
Ms. Nevezi? Yes. Ms. McCory?
Yes.
Mr. Pratt?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
All right, Marnie, we're back to you.
Okay, before we call case 588, is anyone else present in Chicago or in Springfield for a campaign disclosure case wanting to address the board?
None in here.
Okay, in that case, can I take another really quick break before we call SBE versus Friends of Don Harmon for State Senate?
Absolutely.
Grab some water. Thank you.
Yes.
Oh, sorry, Madam Chair, we're ready in Chicago whenever you are.
All right, we're ready. We're back, called back to order, and Marnie, it's back to you.
Okay, so the next agenda item, 5A8. The case is SBE versus Friends of Don Herman for State Senate, appeal number 25 CL1. I'm going to give the board a bit of a refresher and some ideas on how to proceed in this case, and then Mr. Casper will have the opportunity to address the board before any votes are taken. So this matter is an appeal of penalties against respondent committee for accepting contributions in excess of contribution limits contained in section 9-8.5 of the election code. As I mentioned, Mr. Casper, Kasper, is here on behalf of the respondent committee. I understand that the board spent almost 90 minutes on this case at the October meeting, so I'm not planning to re-review all of the underlying facts about the contributions at issue. But I will say the central question in this appeal is one of statutory interpretation, whether this committee's candidate self-funded in an aggregate amount of more than $100,000 under Election Code Section 9-8.5H during the time period when the contributions at issue were received. An act of self-funding, as we all know, lifts contribution limits for everyone seeking the same office as the self-funding candidate. Once an act of self-funding occurs, the question is, for what periods does section 9-8.5 lift contribution limits? Now, if limits were lifted at the time the relevant contributions were received, then there was no violation of section 9-8.5 and there can be no penalties owed. However, if the contribution limits remained in place at the time of the relevant contribution limits, then the penalties would be assessed because the committee would have violated section 9-8.5 by accepting contributions within 30 days of a statutory notice, asking the committee to return or otherwise dispose of the funds pursuant to section 9-8.5J. So the recommendation of the hearing officer and of the Deputy General Counsel in this case on the merits of the appeal was to find that the board lacks jurisdiction to determine the constitutionality of section 9-8.5J and to deny the remainder of the appeal and assess the penalties as the respondent did not show that the penalties arose from an erroneous interpretation of section 9-8.5. Now, at the October 2025 meeting, there was a motion to reject the recommendations of the hearing officer and Deputy General Counsel. That motion failed by a vote of 4-4, and no board action was taken as a result on the merits of this case. Well, one could argue the appeal, we'll let Mr. Casper talk in a few minutes. So my recommendation to the board today is to first vote on whether to impose the penalties contained in the June 5th, 2025 notice. If at least 5 members vote to assess the penalties, then I can recommend an additional clarifying motion to ensure the board's action is clear for judicial review if needed. Conversely, if at least 5 members vote against assessing the penalties, then the appeal can be granted because no violation of the election code was found and no penalties would be owed. Now, if the board votes 4-4 on whether to assess penalties, no penalties will be owed because there will be no determination by at least 5 members that the committee violated section 9-8.5. If no penalties are assessed, the respondent committee would have no reason, I assume, to seek judicial review because it has not been adversely affected by the board's judgment, and this case would effectively end, although I'm sure Mr. Casper can weigh in on that further. But nevertheless, if a tie vote occurs, I do still recommend polling the board members on the reasons for their vote to ensure the results of the vote are clear and to follow the directions that courts have given to the board on what to do in the event of a 4-4 vote. So after the board votes on whether to impose penalties, I recommend taking one additional vote to ensure it is clear the respondent's constitutional challenges to section 9-8.5 are dismissed for lack of jurisdiction. In Delgado versus Board of Election Commissioners of City of Chicago, as well as numerous other cases, the Illinois Supreme Court has held that administrative agencies have no authority to declare statutes unconstitutional or even to question their validity. The site is 224 Bill 2D 481 2017. So here, my understanding is even the respondent agrees that the board lacks jurisdictions over the constitutional claims, and therefore, after the initial vote, I will ask that the board dismiss the constitutional claims. But I think it's easiest to first take up the threshold issue of imposing penalties, and then we can sort out the finer details once we see the results of that first motion.
Madam Chair, if you're finished, Marnie.
Yes, because, Member Watson, please.
Yes. I wanted to bring to the attention of my fellow board members that in 2006, the Illinois Supreme Court addressed the issue of allegations by staff employees and found that such allegations, fines, and penalties, etc., must be approved by the board itself by a majority vote in order to take effect. Therefore, I was very surprised, as you will recall, when Mr. Newman indicated that he was going to proceed to foreclosure, and that would have been without a majority vote taking effect. Therefore, I have a motion to reject the assessments, fines, penalties, escheatment, and everything else that was contained in the June 5th, 2025 notice.
I second that motion.
All right, there's a motion moved and seconded, but Marnie, would you like to respond, please?
I just want to know, do you want to offer Mr. Casper a chance to speak before you vote?
Mr. Casper, do you want to speak before or after the vote?
Before, briefly, if I may.
Proceed.
I'll probably have more success after, but I thank you, Michael Casper, KASPER, on behalf of the respondent committee. I agree and concur with Ms. Malowitz's summary of the status of the matter. I think that I agree with her that making comments about the reasons for your vote is in order as well. I think that you each did that at the last meeting, and I think that we agreed prior to this hearing that standing on what comments you made at the previous meeting would suffice. I'm going to do the same. I was surprised to learn that we were here for 90 minutes last time, so I won't belabor the point. But I would encourage the members to vote yes on this motion. And I'm happy to answer any questions.
Well, Marnie, what was being referenced that happened in 2006?
Sure. Member Watson was referencing a different case that happened in 2006. I don't know if Member Watson stated the name or the site of that case.
It's on the top. If you go to your election code and go to page 299 and begin at the second paragraph, you will see the case that I am referencing. We've had several references to the fact that this was a case of we've never had a case like this before. So it was a case of first impression. My reading of this Illinois Supreme Court case and this heading on page 299, beginning with second paragraph, indicates to me that this is not a first impression case. So we should have known. Well, you will recall my statement at the end of the last meeting. This should be over now, is what I said. I knew of the case. I did not know the name of the case. For the record, the case is Citizens to Elect Collins versus Illinois State Board of Elections at 304 Illinois Decisions 521, and that was in 2006. And that was why I was taken aback and very surprised that Mr. Newman indicated that he was going to continue with forfeiture because this case in 2006 had already been, heard by the Illinois Supreme Court.
Well, I don't recall that being Mr. Newman's statement. I don't recall that at all on our last meeting. And secondly, this was first impression with this board. And that is why I did not want to rule last time, because I did not have information enough to make the ruling. And I think that was a really responsible thing for the board members who didn't have that information to do and to ask for more information before we make a ruling. So thank you for bringing that, Kate, to notice. We will take that under consideration. And maybe, not every case can be found at the touch of a finger during a board meeting.
Well,
Madam Chair, there's a motion on the floor.
there is, but we're in the process of discussion. And I think my frustration is the complexity and the legal, it's all legalese and all this. And I think we need it simplified. And it's this is my understanding, is that one, the candidate was notified that there was a problem, there was a violation. There was nothing done with that. Then they were notified of the assessment and the fines. They appealed in a timely manner, came back to the board. We said, fine, we disagree, but we'll put it to an outside hearing officer. So it went to a hearing officer. Mr. Casper had the opportunity to present his case. We came back from that hearing officer, and that recommendation agreed with the recommendation of our general counsel. Then it went to the board last month, and where was a stalemate. Then it came, here we are today. Now, it's my opinion, if we stalemate again, then it's moot, just like you indicated, and I think somebody indicated. But the problem's going to be, what's forward? What do we do? What's the board do? We're in kind of a limbo. We won't have any direction because we've had recommendations from a hearing officer, our general counsel, and we don't know what an election cycle is defined. And I think will be incumbent on the legislature to either give us that or the court or somewhere, but we're in kind of a limbo. And that's my peace of mind. So does anybody else have anything to say?
Well, I have a question, and Marnie, stop me if I'm not correct, if I'm thinking too far ahead. When this first came up and it was a board assessment, it didn't come from an outside source. It wasn't an outside objection. It was a board assessment. Do we, like in our board packet right now on page, hold on, on page 189, we take a vote on those assessments, correct? So did we take a vote on this assessment?
This is the vote. We are now taking the vote on this assessment, and these penalties can only be imposed if we get 5 or more yes votes. Or rather 5 or more votes wanting to impose the fines. So if it's 4-4, or if fewer than 5 people want to impose the penalties, there will be no penalties.
So the assessments we vote on for right now on page 189, how are those different than this?
Those are different because they are addressed in our administrative rules more specifically in Title 26, Illinois Administrative Code, Rule 125.425C. That lays out very specifically the assessment letter process for late penalties. The process is different under statute for violations of section 9-8.5, and our rules are not as explicit on what to do in that case. However, no matter what, unless 5 board members vote to impose the penalties, we are not imposing the penalties.
Okay, now I just want to know the difference. Thank you. I want to know the difference between this one and those.
Right, so yeah, if you take a look at 125.425C, you can see the entire assessment notice process for late filings.
Madam General Counsel, is it fair to say that these assessments that Member Cray is referring to have either been adjudicated or the party has not shown up? So there's been no ability to adjudicate it?
All of those parties in late filing cases are sent an assessment notice and given an opportunity to appeal. If they appeal, we hear their appeal, and then the board votes on it. But if they choose not to appeal, the board can assess a fine. However, then the committee has an opportunity to file a motion to reconsider, in which the board can reconsider and at that point decide to overturn the fine. So essentially, they have multiple opportunities to go before the board to argue that these assessments are incorrect.
Thank you.
I believe there, Madam Chair,
Yes,
I believe we've heard enough that I need to hear today. If we can, let's move on with the vote and let's see how it works out.
Does anyone mind retelling the motion? So
yeah.
I know exactly.
Thank you.
Cassandra, if you would restate your motion, please.
My motion was to reject all of the assessments, all of the allegations of assessments, fines, penalties, escheatment, everything that was contained in the June 5th, 2025 notice.
Is there a second?
I second.
Jennifer seconded it. It's been moved and seconded. Roll call, Amy.
Ms. Ballarcroft,
Yes.
Ms. Craig,
No.
Ms. Genovese? Yes. Ms. McCrory,
No.
Mr. Brett,
No.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
No. Now, oh. Amy, or Amy,
Madam Chair?
yes.
Just for the clarity of the record, I would like to now make a motion to impose an order, enter an order imposing the assessments contained in the June 5th, 2025 notice payable within 30 days. I recognize that we in some ways already did that, but just for the sake of clarifying the record, I would make a motion to now impose that same order. Or
Second.
One request would be that we first poll the board members on the previous motion before we discuss that motion, again, to keep the record clear. Before we go ahead and poll on the last motion that just failed as a 4-4 stalemate, if you voted to impose the assessments, my suggestion would be to say that you adopt the reasoning of the hearing officer and the deputy general counsel. If, of course, that is the reason you're saying that. That way it's very clear, all of the findings of fact, all of the conclusions of law that you support. Now, if you voted against the assessments, you do not have to repeat all the reasons that you said at the October meeting. You can simply say, I adopt my reasoning given at the October meeting. But certainly if you'd like to elaborate, you can feel free to do that as well. So the resulting board order here is going to reflect that this vote failed and that no assessments are due and owing. And now I'd like to go through the board members, Amy, and if we can have them called to state their reasons for their decision in rejecting the penalties.
Amy?
Ms. Ballarcroft, oh wait, am I just only the ones that voted no?
No, everybody.
Everybody, okay. Ms. Ballarcroft,
I adopt the reasoning that I expressed in great detail in the October meeting. I also want to add that I had made this vote based on citizens to elect Collins versus the Illinois State Board of Elections 366 IL F 3D 993.
Ms. Craig? I adopt the reasoning of the general counsel and the hearing officer. Ms. Nanavasi?
I adopt the reasoning that I made at the October meeting.
Ms. McCory?
Adopt the reasoning I gave in our October 21st board meeting.
Mr. Brett?
I adopt the reasoning of the Deputy General Counsel and the hearing officer in this matter. I reiterate what I said last month, that I believe that consistency is important and that we ought to treat this committee the same as we have treated any other committee that comes before us with these types of fines. And if we think that the penalty assessment is extreme, then we would address that in a settlement aspect and otherwise comply with the statute.
Ms. Watson?
I adopt my reasoning and rationale at the October 21st meeting.
Can you hear me?
Yes.
All right. We are here today to hopefully resolve the matter between Friends of Harmon and the Illinois State Board of Elections. It is unfortunate that this case has reached this point. As you know, this board is a nonpartisan composed of 4 Democrats and 4 Republicans. Historically, we have reached decisions by a 5-3 votes or greater. However, this case, as we know, has resulted in a 4-4 tie. I am not a lawyer, but I have been part of many cases over the years in the various capacities I have worked. And I have worked with many lawyers and read the different languages as I have here. And at the end of the day, the intent of the language is very important. After studying thoroughly the testimony and documentation from all sides, I have reached my decision with the understanding that we as a board represent both sides of the aisle and we must act impartially. I therefore reject the Deputy General Counsel and Hearing Officer's report for the very reasons given by members Ballard Croft, members Genovese, and member Watson. After I have thoroughly studied all of the different things regarding this case, their rationale follows the law as it is written and intended. This case highlights how ambiguity in the law can sometimes lead to vastly different interpretations. But I have never encountered a situation on this board or in my previous role at the International Union where a tie vote resulted in punitive damages. We must uphold the principle that a majority is required to convict someone. My work history, so you know, is that I would like to reference is that I worked in the past for my International Union as their national political director and their executive vice president under the terms. And our general counsel have always advised me when I was working for them under this that our union was approximately 47% Democrat, 47% Republican, and 6% independent. And we were successful at the end of the day by serving everyone fairly, as I feel I am doing here today. To be honest, in my decision, most of this is common sense in the best interest for all the citizens represented in Illinois, no matter what party we're in. Thank you for listening.
Chair Donahue.
Well, I accept the recommendation of the hearing officer and our general counsel. And the 14 years interpretation that this board has of this law. So if we want to talk about consistency, I think the recommendation of the general counsel and the hearing officer is consistent with what this board has done. So I believe that a 4-4 tie is, again, unfair. It's not, but it is the law. It is the Constitution. And we disagree. So that's my point. Amy?
So thank you for polling. At this point, Member Brett has made a motion. There has been no second. Member Brett, do you mind reminding us what your motion was?
My motion was to ensure the clarity of the record that there would also be a motion and a vote on the question of whether to enter an order imposing the assessments contained in the June 5th, 2025 notice. It could be belts and suspenders, as they say, but I think it's important to clarify the record.
Second?
Yes, second.
It's been moved and seconded. Roll call, Amy?
Ms. Croft?
No.
Ms. Craig?
Yes.
Ms. Genovese?
No.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
No.
Vice Chair Turbin?
No.
Chair Donahue?
Yes.
There we are again, 4-4.
And for ease, could we just refer back to the previous polling?
Yeah, so I would say that a proper response on the polling would be I adopt the reasoning I gave in response to the last vote today. So Ms. Calvin, if you'd like to poll.
Ms. Croft?
I adopt my reasoning on the previous motion.
Ms. Craig?
My reasoning on the previous motion.
Ms. Genovese?
I adopt my reasoning from the previous motion.
Ms. McCrory?
I adopt my reasoning on the previous motion.
Mr. Brett?
I adopt my reasoning on the previous motion.
Ms. Watson?
I adopt my reasoning on the previous motion.
Vice Chair Turbin?
I adopt my reasoning for the previous motion.
And Chair Donahue?
I adopt my reasoning on the previous motion. All right.
All right.
Thank you, Madam Chair, members of the board.
Thank you. I actually
I
have
now
one
move to dismiss,
for lack of
for
jurisdiction.
lack of jurisdiction, the respondents' constitutional challenges to section 9-8.5 of the election code, 10 LCS 5/9-8.5, citing Delgado versus Board of Election Commissioners of City of Chicago, 224 ill 2nd 481 from 2007.
So that is a motion to dismiss for lack of jurisdiction the constitutional claims. Mr. Casper, you agree those constitutional claims should be dismissed for lack of jurisdiction, correct?
I do.
Is there a second for Mr. Brett's motion?
Second.
What do we want?
It's been moved and seconded for the removal of the Constitution objection.
The
Remove
lack of jurisdiction.
the lack of jurisdiction.
May I speak? I have no opposition to this one.
No.
Was there a-
Amy, roll call?
Ms. Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you. And just to summarize, that the board order for today is going to reflect that the constitutional challenges to section 9-8.5 of the election code were dismissed for lack of jurisdiction. And it will reflect that the vote on our first motion failed, that the vote on our second motion failed, both 4-4, and no assessments are due and owing in this case. And as far as I'm concerned, this case is over.
Agreed. Thank you.
Well-
Thank you, Chair, members of the board. Thank you for your time.
Should there be a motion to strike and dismiss or a motion to strike from the call? I mean, how do we get the case off the call, Marnie?
Essentially, the appeal's been denied. So
What do we make?
you want to make an express
What
motion to
make
deny the appeal?
motion
Okay.
Just for clarity.
Okay, sure, absolutely.
Member Watson, do you want to make the motion or do you want? I move that we strike this from our.
Strike.
From the call.
I don't understand the meaning of that motion.
And I second your motion.
I think the general counsel is asking for some elaboration on it before we second it.
I think what would make sense to me, and obviously I don't get to make the motions here, would be a motion to deny the appeal.
Oh, no.
Well, you know
No,
what?
we're
You're
not going
right.
back to
You know
the
what?
appeal.
No. You're right. Okay. I'm sorry. Proceed on your motion. Ignore me.
So the motion is to remove the case from to strike it from.
From what?
Doesn't it by operation of law go away? I don't
No,
understand
it
why we're
doesn't.
making another
No.
motion.
Oh.
I think it's over. I think it's over and Mr. Casper
Well,
thinks it's
we've
over.
just done
but-
a belts and suspenders
It'll be over.
past one, so we'll do a belts and suspenders motion here.
Then I would encourage a yes vote. I agree. I agree with the general counsel that the case has been resolved.
So you want her to withdraw her motion?
No, I support the motion. I think it should not return to the call. I don't know if it does automatically get removed from the call or not, but
if this particular case, but if there are other complaints filed on this same scenario, then that is allowed to be heard by the board.
I agree.
Let's be clear.
Sure, but here we are only talking about one case, and that case we are talking about is
26 CL.
there, 25 CL 001.
Yes,
So-
I would rather have the motion clarify that this is this particular case.
Okay, I'll accept that friendly amendment, yes.
I have
And
no
what,
objection.
and the motion is to just strike and take it away?
Yes.
Is there a second?
I second it.
That's true. Roll call, Amy.
Ms. Fowler Croft,
Yes.
Ms. Curry? No. Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
No.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
No.
Motion passed.
All right.
Agreed.
What's over?
Well, so my intention here is to, I'm sorry, we have to poll again.
No.
No, okay, pass 5-3.
Oh, it was 5-3. Oh, my fault.
Yes.
I'm sorry. Okay,
Yeah.
excellent. I'm sorry about that. Okay, so the case is stricken.
Thank you, everyone, unless there's anything further from me. Okay.
All right. Barney, you're up next.
Okay, we have a few cases to return to under settlement offers for agenda item 5A3 and 5A4. The recommendation is to reject the settlement offers.
Do I have a motion to that effect?
I move to accept the recommendation to general counsel and reject the settlement offers.
Second.
Amy, roll call, please.
Ms. Fowler Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson? Ms. Watson?
I'm sorry, yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Okay,
Marnie?
agenda item 5A7. This is a bit of a tricky case, but I think I can summarize it by saying, I do agree with the hearing officer that the committee has proven that it did not violate the law. In order to clarify that we have jurisdiction here, I would modify the hearing officer's recommendation and states that the committee's motion to reconsider is granted rather than calling it an appeal. But the outcome of this recommendation would be that there are no fines owed, and therefore my recommended motion would be to accept the recommendation of the hearing officer as modified by the general counsel and grant the motion to reconsider.
Is there a discussion? Is there a motion?
I move to accept the recommendations of the hearing officer as modified by the general counsel and grant the motion for reconsideration.
Is there a second? Been moved and seconded. Amy, roll call, please.
Ms. Fowler Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right, Marnie, appeals?
Yes, so we have two more appeals left to decide. Those are 5A9 and 5A10, and the recommendation is to deny the appeals.
Do I have a motion?
So moved.
It's been moved and seconded. Amy, roll call, please.
Ms. Fowler Croft?
Yes.
Ms. Cray? Yes. Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
All right. Other campaign disclosure items? Marnie?
So agenda item 5A12, we have some assessments requiring final board orders. As we discussed during the Harmon case, the assessment notice process for late filings is codified in Rule 125.425C. If you'd like to refamiliarize yourself with that, I'm glad this came up. So that's a rule to take a look at it. But for the meantime, is there a motion to enter the orders assessing penalties as listed on pages 189 to 195 of your packet?
So moved.
Do I have a second? It's been moved and
Oh, then I second.
roll call, Amy.
Ms. Bellercroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Present.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right. Do we need to do anything with 2A13?
That is purely informational. It's a list of the good committees who paid their fines.
All right, then we'll go to 5AB.
Excellent. So this is a consideration of proposed amendments to the rules in Part 208 of Title 26 of the Illinois Administrative Code regarding statewide questions of public policy and constitutional amendments petitions. The Illinois Constitution requires at least 8% of the total votes cast for candidates for governor in the preceding gubernatorial election to qualify for ballot access. That's Illinois Constitution, Article 14, Section 3. The statute 10 ILCS 5/28 just say Article 28 also requires the same amount of signatures for statewide public advisory questions. So under this proposed rulemaking amendment, after a constitutional amendment petition or statewide question petition is filed, board staff would use the same process it has used for at least 15 years to count how many signatures appear on the face of a petition without regard to validity. If the petition meets the minimum signature requirement on its face, the petition would automatically move forward to random sampling and verification of signatures under Article 28 of the Election Code. However, if the gross number of submitted signatures falls short of the statutory requirement, then the board under this rule would be afforded the opportunity to consider whether to order that the petition does not statutorily qualify for the ballot and that no random sampling will proceed. Now, if the gross number of signatures is disputed, however, the individuals supporting the petition would have an opportunity to contest the initial signature count before the board. The board would then have discretion to determine that random sampling and verification should in fact proceed. This process interprets and applies the statutory language of Article 28 in a way that ensures agency resources are not spent on random sampling and verification of signatures for a petition that never included enough signatures to qualify for the ballot in the first place. So today, we are seeking board authorization to file the revisions to Part 208 with JCAR to begin the public comment period. And I do want to point out that if the board receives public comments and wants to change the proposed rule following the public comment period, that is still an option that the board can pursue. So I'm asking for a vote only to file the rules and begin the public comment period.
All right, is there discussion?
Right here.
Sorry, looking up there. Chris, hang on just a second.
I just want to go on record that I will be a no on this. I believe this rule exceeds statutory authority.
Can
I
I,
have a
can I ask
question.
him? Okay,
Oh,
sorry,
go ahead.
Member Watson, go
No,
ahead.
Go ahead.
Member Watson?
Um, what is the statutory authority that, Marnie, what is the statutory authority that, that Member Clay is, referencing?
I don't know exactly what member Cray is referencing, but I can tell you the statutory authority that is cited in the proposed rule. That
Oh, I
is.
was gonna say, I can tell you what my comment is. It's 28-11 gives only the proponents the right to a hearing. We're giving the opponents are also mentioned in this rule. If I could read, the rule gives opponents right to hearing. There are definitions in the election code for opponents. They must be registered. Could I ask, where is this list? Do the opponents have to be registered prior to this filing? The rule talks of proponents and opponents. It does not mention filers or the group that specifically filed the petition. Is the filer an automatic proponent? The proponent has to defend the validity of the signatures. There is no basis for the opponent to present evidence at the hearing. Sole purpose is for the proponent to defend the validity. The proponent then has a statutory duty to validate the whole, not just the random sample.
Oh, well, I have to go along with Member Cray then. I'm sorry.
I have some questions. I want to clarify this. I mean, I've never run for office. I've never had to file a petition. But the case that we had earlier, Minaric, clearly he fell short with 3 signatures on a petition, required to have so many more. I don't understand why we wouldn't have the authority to weed those out from the get-go in order to get that fluff off the ballot or get that fluff off of somebody's desk so that they don't have to deal with that. I don't understand why we wouldn't have, I mean, somebody tell me why we shouldn't have that authority to be able to, something that's so obviously not valid, to get off the desk of somebody who shouldn't have to deal with that.
Marty, this is for you again.
I'm having trouble hearing you, Rick.
Like those mics you guys have. Again, I'll say that.
I still can't
I
hear.
can't hear you.
Yeah, I can't hear you at all, Rick.
Hear me now?
Not really.
Is that microphone turned on?
It's on.
Okay.
Can you hear me now?
Yep.
Yes.
Marnie, please repeat what you said. This is for JCAR to look at, public comment to make, then come back to us to vote to proceed for a vote on it. Is that correct?
That is the permission that I'm requesting.
There you go. Thank you.
And I just want to clarify, so.
That's what she said. Hang on. Right.
Can I?
Sorry, I just want to clarify that we aren't going to go through these signatures and decide which ones are, valid and invalid. We're just purely counting the signatures, and if there are not enough, then sending it. Is that accurate, or are we actually validating signatures? No.
So this is a process that would happen before any validation of the signatures.
So just like we did earlier today, it would just count the number of signatures, and if there are not enough, we would do similar to today's situation.
So the legal reason for it is slightly different. That's an apparent conformity standard.
Okay.
This is slightly different. Our authority comes from different places, including from the Illinois Constitution, as well as from section 1A810 of the election code that reads that it's the board's duty to, quote, determine the validity and sufficiency of petitions filed under Article 14, Section 3 of the Constitution of the State of Illinois, 1970. There are also citations to section 1A-89, which involves rulemaking to implement the statutes within our code. It also cites to sections 28-3, 28-9, and 28-11 of the election code. So it does differ from an apparent conformity standard, but the idea is that if 1 million signatures are required, it's not really that high, but if 1 million signatures were required and someone only submits 800,000 signatures, they can say, no, we really think we have 1 million on the face of the petition, and they can come to the board and they can say, the board counted wrong, and therefore we should get a random sample. And then the board can say, no, you're 200,000 signatures short, or the board can say, maybe that's possible. Maybe you do have enough signatures, and then the board can vote to proceed with a random sampling and verification. So the board gets to decide whether the random sampling continues. Whereas if there were 100% of signatures on the face, just as it is now the case, or rather the petition would proceed automatically to the random sampling and verification process.
I have another couple questions if I could, please.
Yes, Member McCrory.
It's my recollection that each petition has page numbers and each petition has signature lines that are numbered, correct? So to not abuse the term apparent, if we were in a scenario that there were, 20,000 signatures required and we only had 3 on its face, it looks like the petition should be rejected. My next question, am I right in that? Am I right in thinking that that's how the petitions are numbered, page numbers, line numbers, and so on?
If it's done properly, ideally it has that, but we have an entire process that can reflect, even if there are errors, we can still come up with a staff count of signatures. And then there can be a hearing on whether the verification process should proceed.
And in furtherance of my education on this matter, once this goes to JCAR and there are comments, what kind of report will we get in order to make a final decision on this?
So I think there's 2 possibilities. Well, I think that maybe the best thing to do would be to submit the actual public comments to the board, so you can all read them. And from there, we can decide, do we want to scrap the rule? Do we want to make some modifications to the rule? Or do we want to continue with the rule as written?
Okay.
That's the process I suggest.
Madam Chair.
Member Watson.
Tani, can you explain to me why you think this is all right? Tani.
Mark.
Member Genovese.
Oh, Tanya.
I'm not saying that it's actually necessarily right. I just wanted verification and some clarification that we weren't actually, going to validate signatures. We are literally just looking at the face of the petitions, how many signatures there are. And then if there's not enough signatures, going to the next step versus us interpreting anything. Similar to what we voted on earlier today.
I think my understanding was that this had already been agreed upon by the legislature. Is that incorrect?
That's incorrect.
Yes. It hasn't gone to JCAR yet. We haven't sent it to JCAR.
So the legislature.
That's what we're doing now.
So the legislature has had nothing to do with this.
No.
The legislature passed statutes, and the Constitution says that you must have a certain amount of signatures. But these particular rules, this particular process has not yet gone before JCAR And JCAR is comprised of legislatures.
What was the statute that the legislature passed? I'm sorry if I'm, being redundant. I'm just not getting this.
No, certainly, that would be sections 28-3, 28-9, and 28-11 of the election code, which set signature requirements and require this sampling and verification process of signatures. We also have the Illinois Constitution provision that requires the 8% of signature.
Okay, all right. So I heard all this before. Okay, so I guess what I'm asking, Marnie, is, you're looking for a constitutional amendment. Well, what are you looking for?
No, we're just looking for a rule that says that if there is a statewide referendum or a constitutional amendment petition filed, and then on the base of that petition, they don't have enough signatures to qualify for ballot access, then there's a board hearing. And the board can decide, should we proceed with the random sampling and verification process? Or should we reject the petition as facially insufficient?
Okay, all right, all right.
If I can say, I mean, personally, I don't know why it would be a bad idea to get comments. I mean, certainly we're going to have some attorneys weigh in on this and give positions on it. Right now, I don't think that we have enough education to reject this. At least I don't.
Member Craig?
Okay, I just want to restate, I know Tanya specifically asked about signature verification, and it does say on page 201 D1A that we would do a random sampling and signature verification. So I want to make that point. Two, as I said earlier, I believe that in 2811, the rule exceeds statutory authority. I said why, because it only talked about proponents, but I also think section 28-9 talks about advisory questions. Any petition sheet issues aren't to be considered part of the petition for the random samples. Constitutional amendments are silent on this issue, and this rule treats them the same. So I think those two things really have to be looked at. And that is my concern. And I know that this is maybe some of the first time you guys have been doing this, hearing about this. I've been fighting this since Rick and I got it back in like September. I've been saying, I think we're exceeding our statutory authority here. I think we're exceeding our statutory authority. If people want to vote, have it go to JCAR, yes, I do think we're going to get some very heavily worded opinions, but I'm still going to vote no. I would like to get this worked out before we take up JCAR's time. Thank you.
I guess my question is, and my next question is, if we go with the process of a petition can fail as an opponent contesting it, filing a complaint, what about those petitions that only have 3 signatures on it? And they should fail. And because nobody's brought any sort of complaint against them, they don't. So I would like some more education on this, and I think that getting some comments on it would be helpful to help me make my decision.
Madam
All
Chair,
right.
Madam Chair, very briefly.
Member Brett?
Very briefly, I think that what Ms. Craig said, and I believe Ms. Watson agreed, that the concern is that automatically involving opponents in the process exceeds the authority. I don't think that the question is that there's not authority to do an apparent conformity. I think that the concern that they raised was that we would be exceeding our authority to automatically include opponents in that process. Just want to restate that. If I restated it incorrectly, please let me know. I will say that after we get back the comments from JCAR, assuming this goes there, I have concerns with us promising to do all of this within 3 business days. Our staff is very, very worked, and this seems like this would be a big process. And I don't want us by regulation to promise to do this always in 3 business days, when we could probably do it within several weeks. And without taking up too much of staff time. And we could still do it faster, but I would suggest that we not mandate it within 3 business days.
If I could just correct you, we just issue a notice within 3 days. We don't actually do the count within 3 days.
Within 3. That's why we have an amazing general counsel.
Well, for what it's worth, Bernadette just whispered this in my ear, so I think we have an amazing executive director.
We have amazing staff.
Yeah, and the purpose of this in many ways is to keep from a huge use of resources with petitions and then have them come up so short. So do we have any other discussion? Do I have a motion?
I make a motion, we take part 208 constitutional amendment and send it to JCAR as proposed.
I'll second.
It's been moved and seconded. Roll call, Amy?
Ms. Bellarcroft,
Yes.
Ms. Cray?
No.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passed.
Great, thank you. So my intention from here, we'll publish the rule. We'll have our 45-day comment period. I will gather all of the comments and I will give you the comments. So you all have time to deliberate and think about whether we want to proceed with this rule, whether we want to change the rule, or whether we want to abandon the rule.
Okay, that's wonderful, Marnie. We appreciate that. Now are you done?
I am done. Thank you.
I'm sitting here looking and you're not. All right, well, we will turn it over to Bernadette and report of our executive director.
Thank you. The first item on my report is established party candidate petition filing overview. I am going to allow Brent Davis, Director of Election Operations, to provide an oral report since Brent primarily oversees filing day and I do not want to take all of his credit. I do just want to say it was a successful filing day. Obviously, you can't object unless you receive candidate petitions. We received a lot of objections, so I will say that speaks to the success of the filing day, of the agency and staff receiving them. It is an all hands on deck day. Everybody is present, everybody contributes, but overseeing it mostly is the Election Operations Division. So Brent Davis is going to give a brief update since we've been here for a while, and we like to be brief when we're successful. So Brent, thank you. I'll turn it over to you in Springfield.
All right,
Yes.
Brent.
All right, thank you. So as Bern mentioned, we will keep it brief, but I do want to give you some of the basics. It was a very successful filing period. It was a little bit busier than normal. So filing started on October 27th. And as we commonly do, we had a line that stretched all the way down the parking lot. And so as we processed those, beginning at 8 a.m. when we opened the doors, we had 397 petitions that we processed, and we finished that a little bit before noon. At that point, we transitioned to scanning all of those petitions, breaking them down, cataloging them, and then making those records available. We finished all of that process by 8 o'clock and filled all of the requests that people had made for copies. So we got through a lot of stuff by 8 o'clock. The number that were filed this year were about 100 more than 2 years ago. So it was a higher volume this time. We had more offices, all the statewide constitutional officers, plus the U.S. Senate seat. So a large volume of filers. in addition to all of the agency staff, this being an entire agency project, we also work with other agencies as well. So Secretary of State Index Department was also present, and they had representatives here that morning beginning at 7 a.m. so that candidates could file their statement of economic interest. We worked with the Illinois State Police, and they had a number of troopers here to help with security and have that presence throughout the whole morning. And we also had Secretary of State Police here as well. So a strong presence to make sure that everything went according to plan and everyone was safe during that process. Following that initial filing, so we had a total of 277 offices, including judicial vacancies, 45 petitions filed during the final hour of filing to qualify for the last ballot position lottery, resulted in 634 total candidate petitions being filed during this period. The highest filing, or the highest office with the most candidates that filed, was U.S. Senate with 22 candidates, 8 Republican and 14 Democrat. We conducted our lottery on the 12th, and we are currently in the special judicial filing period, which will conclude on Monday. So those are the high spots. I'm happy to answer any questions if anyone has any, but those are the basic details.
Questions?
I don't have a question, but I do have a comment, if I can. I would like to say all of you did a phenomenal job. Years ago, when I was the statewide Illinois AFL-CIO campaign director for all labor for the state of Illinois, the machines that were holding the glue together for all the campaigns, no matter which party we were in, was always Cook County and Springfield, Illinois. And I was glad to be here the other day when you guys were doing this, because it still shows me just how great you guys are, because that is a machine, and that was a well-run machine. Even with the technical hiccups that you guys witnessed, you resolved them as quick as you could. I couldn't be more proud of a team of people than I saw that day in this office and the way you handled all that crowd out there. So kudos to you guys.
Thank you.
Ditto.
Thank you.
We appreciate it, Brent, very much, and the whole, everybody, truly. Bernadette?
Okay, thank you. The next item under legislative update is the consideration of spring 2026 legislative agenda. I see that Brian Pryor, our senior policy advisor, has taken his seat. He will be available to summarize the memo that he provided, as well as answer any questions. I did just want to hit the highlights that the proposal is fairly minimal and mostly is related to operational changes that would assist the agency or address concerns, not necessarily policy related, as is typical of the board. Several of the items are holdovers from our last legislative agenda, being that an omnibus was not approved, and that several of those items were introduced in a draft omnibus, but not moved forward and approved by the General Assembly. So those have been reincorporated, as well as just a couple additional items. So I will thank Brian for his help in pulling this together with the legislative subcommittee, and turn it to him just to answer any questions and to include any other additional information.
Brian?
Happy to answer any questions.
Look, we appreciate everything you do.
So we're cool? Nobody has any questions? I'm good with you guys. Good, go. All right.
My
You will
goodness,
have-
Brian left that seat very quickly. I guess he didn't want to stay for the motion. I will request from the board now a motion to approve the agenda as presented in the memo.
So moved.
There's a motion and a second. Amy, roll call.
Ms. Delacour?
Yes.
Ms. Craig?
Yes.
Ms. Vacy? Yes. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Ms. Watson?
Yes, I'm sorry.
Okay. Vice Chair Turbin?
Yes.
Chair Donahue?
Yes. All right. Bernadette?
Okay, I would thank Brian, but I don't know if he's left the room as well. The next item is also one that does need board consideration and approval. It is the 6-month review of executive session minutes. So this is pursuant to section 2.06D of the Open Meetings Act. A public body is required to review the minutes of its closed meetings to determine whether or not a need of continuing confidentiality exists for those minutes. In accordance with this requirement, Marnie and I reviewed the minutes for the period of April 15th, 2025 through September 16th, 2025, and have concluded that the necessity for confidentiality does not exist. Therefore, we would just like a motion and approval from the board to, that the confidentiality no longer exists and allow the release of the minutes.
Do we have a motion to that effect? Do I have a motion to approve the minutes?
Second.
Amy, roll call, please.
Ms. Bellicroft?
Yes.
Ms. Craig?
Yes.
Ms. Vacy? Yes. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right, Marnie, Bernadette, I think the rest of it is basically informational.
Yes, informational items related to voter registration activity, grant funding update, FY25 fiscal status reports, and the 2-year plan of staff activity for the months of November and December is informational.
Member Craig?
I have a question about the budget. Well, two things, actually. One, on page 219, is that a typo, or did we go from 1 million to $10 million for our IVRS revamp? Because last month it was 1 million. And if we went up another 9 million, I think we need to talk about this.
Hello.
Hello.
So last month it was a typo. It is a 10 million because if the IVRS.
Hold on, please. I need to know who's talking right now, please.
Okay. All right, that is our chief fiscal officer. Her name is Elena Gutsalenko. I can provide the spelling to you.
Okay, thank you.
Go ahead, Lena.
Yes, this IVRS for the IVRS revamp is a very big project, and we put in the documents for 5-year term. We're looking for 5-year contract with the renewal of this contract for another 5 years. So we understand that we cannot estimate the cost of the project because it's such a large one. So 10 million is just a number that we put in the bid bucket.
Does that answer your question?
Well,
So the actual
doesn't give me
bid,
reassurance. It answers my question.
the actual bid might be very different from 10 million.
Okay, and this is for starting now for 5 years forward, is that correct?
Well, yes, that it is correct. So the bid is not back yet.
Okay.
So the bid closes on March 31st of 2026. So after bid closes, we will draw a contract based on who will be chosen for the bid. So most likely the contract will not take effect until maybe May of 26 or even further into that. So
But you want to pay the whole thing out of this fiscal year?
No. This is the informational only. This 10 million has no part in 26 budget.
Even though you're going to sign the contract in May of 26?
Right, because we will not prepay the contract. We will pay for the services performed.
But your estimation is 5 years. Over that
Yes.
period of time.
Yes,
Okay, so you're going to pay everything out of FY27?
not everything, for the work completed in stages.
Okay, so you're doing this in stages.
Yeah.
So do you think this is gonna be your total for those 5 years?
We hope so.
Okay.
Yes.
Or less.
Okay.
Or less.
Okay, so you're not taking all of this out of FY 26?
No, no, no.
Okay, okay,
That answers the question.
okay, that answers my question, but I had one more. And I hate to speak for a division head, but I'm going to. Tom Newman, I'm gonna speak for you. If there's any way, I see you've only spent $101 so far, and that's why I'm speaking to this. Can we look into getting a new microfiche machine? That machine was broken when I got here in 2002. And I know Matt Dietrich uses it, and I would like to help his eyes and anybody else. So could we please look into getting that machine fixed, please, or getting a new one? I see you've only, like I said, you only spent $101. So, and maybe we could transfer, I don't know, some of this 10 million that we're not spending. And get a new piece of equipment, please. Thank you.
Said,
Noted.
noted in Chicago, noted Bern.
Yeah.
Yes, noted.
Okay, I'm just, whatever. Thank you, Elena.
Along with the microphone.
Yeah.
And shall I go on, Bernadette? Are you done?
Yes, I am done.
All right. Do we have other business? If not, do we have comments from the general public? Is there up there?
No public.
Bernadette, none?
Done.
All right. So, I need a motion to go into executive session.
For the purpose of freedom.
Oh, I'll read that. Hang on. We're distracted. We've got action down here, guys. All right. I need a motion to go, to recess into executive session for the purposes of discussing the appointment, employment, compensation, performance, or dismissal of specific employees, pending litigation and the minutes of October 21st executive session meeting pursuant to sections 2C1, 2C11, and 2C21 of the Open Meetings Act 5 ILCS 120.
So moved.
Second.
Roll call, Amy.
Ms. Bellicroft?
Yes.
Ms. Craig?
Yes.
Ms. Innovative? Yes. Ms. McCory? Yes. Mr. Brett?
Yes.
Ms. Watson?
Yes.